I'd like to call this meeting of the Tennessee Real Estate Appraiser Commission to order. We'll begin by a roll call to my right. I'd like for you to announce your name and your residence.
Rosie Johnson, Paris.
Gary Standifer, Franklin.
Norman Hall, Brentwood.
Mark Johnstone, Jackson.
Tim Walton, Collierville.
Ed Barilla, Johnson City.
Okay, we have 6 members present, which does constitute a quorum to conduct business. This regularly scheduled commission meeting is taking place in the first floor conference room of the Davy Crockett Tower, 500 James Robertson Parkway, Nashville, Tennessee. And notice of this commission meeting was posted on the Tennessee Real Estate Appraiser Commission website on January the 2nd, 2014. At this time, I would entertain a motion to adopt the agenda.
So moved.
Second.
We have a motion to approve, to adopt the agenda from Commissioner Hall, seconded by Commissioner Walton. Is there any discussion on the adoption of the January 13th, 2014 agenda? If not, all in favor signify by saying aye.
Aye.
Any opposed? The agenda has been adopted. At this time, we'll have the director's report. Director Avers, you are recognized.
Thank you. If you turn in your iPads, the director's report is included in your attachments on page. The first item is the Association of Appraiser Regulatory Officials will be meeting in San Francisco, California, April 11th through 14th, 2014. And I recommend the commission send 3 board members, and the executive director and the board attorney to the conference. And I recommend the commission vote as to which members to send. And I recommend the chair, the vice chair, and the AMC member be sent.
We need to take action upon this at this time.
I need a vote from the commission to approve those
Okay.
expenses.
You've heard the director's recommendation. Do we have a motion to that?
Make the motion that we accept.
Second.
So we have a motion from Commissioner Walton, seconded by Commissioner Hall, to accept the director's recommendation of sending 3 board members, which would consist of the chair, vice chair, and AMC member, along with the executive director and board attorney, to the Spring Aero Conference. Is there any discussion? If not, all in favor signify by saying aye.
Aye.
Motion approved.
There's only one other item of business I have for the director's report, and that is, this is very likely going to be Dr. Barilla's last board meeting. So I wanted to make sure we gave him a plaque of recognition. He's already 6 months past his expiration of his term, and I just wanted to give it to him first.
Thank you for your service, Dr. Barilla.
Thank you.
We appreciate you.
My pleasure.
And that concludes the director's report.
Thank you for that brief and excellent report, Director Avers. The minutes from the December meeting have been distributed. Has there been an opportunity to review those minutes? And if so, I would entertain a motion for approval of the December 2013 minutes.
Make a motion to accept.
We have a motion to accept the December 2013 minutes, seconded by
Second.
Commissioner Walton, is there any discussion on the December 2013 minutes? If not, all in favor signify by saying aye.
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 Any opposed? December 2013 minutes approved. Report of education interviews and recommendations. Okay, we
Experience
have-
interviews.
We have Commissioner Hall, I'll recognize first, who had the opportunity to interview Mr. Benjamin Kuntz, who is trainee 4566 and is requesting an upgrade to certified residential. Mr. Hall, you are recognized.
I interviewed Mr. Kuntz, and his work, I think, is equal to or better than some. So therefore, I would recommend he be approved for CR.
We have a committee recommendation for approval of Mr. Kuntz's experience. Is there any discussion? If not, all in favor signify by saying aye.
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 Excuse me? Well, let me ask, in some areas, under Robert's rules, if a committee makes a recommendation, there's no motion and second required. I'm not sure if that's applicable in this, but no, I mean, I don't know. I'm asking legal. I mean, I know some bodies have different rules, but for the sake of being safe, you've heard the committee recommendation. Do we have a motion for approval? Can somebody make a motion to approve Mr. Kuntz's? Okay, we have a motion from Commissioner Johnson, seconded by
Second.
Commissioner Walton. Now, any discussion on Mr. Kuntz's experience? If not, all in favor signify by saying aye.
Aye.
Motion approved. Mr. Gary Staniford, Commissioner Staniford had the opportunity to interview a Miss Darlinda White, who is trainee 4416, who's requesting an upgrade to certified general. Commissioner Standiford, you are recognized, sir.
Thank you, sir. I interviewed Miss White. Miss Avers sat in on the interview with me. Additionally, while they weren't in the interview, her immediate and regional supervisor are here today and were included in the interview at the end of it for a session. I'd like to thank her supervisor and her regional supervisor for their interest and their support for this trainee. There were 7 reports that were in-house appraisals of rural residential properties. There was one appraisal, a form report that was more comprehensive, and it was a rural residential property as well. This report was utilized the 3 approaches to value and typically utilized the ag income approach to value as well, or included. Having reviewed the reports, I was not comfortable with approving recommendation for approval based on a recommendation from Ms. Avers, and as not necessarily agreed upon, but based on income or based on input from Ms. White and her supervisors, it's my recommendation that Ms. White provide a demonstration appraisal of her choosing on a small or any type of commercial property that utilizes the 3 approaches to value, and submit a couple of additional income approach appraisals utilizing the ag income approach, similar to the one report that she did supply that utilized all 3 approaches. That is my recommendation.
Thank you for that report, Commissioner Standiford. You've heard the committee recommendation.
I make a motion to accept the recommendation of Commissioner Standifer.
You've heard, we have a motion to accept the recommendation from Commissioner Hall. Do we have a second?
Second.
A second by Commissioner Johnson. Any discussion? If not, all in favor signify by saying aye.
Aye.
Any opposed? Recommendation approved. Commissioner Walton had the opportunity of interviewing Mr. Otis Smith, trainee number 4444, who is requesting to be upgraded from trainee to licensed. Commissioner Walton, you are recognized, sir.
This is my second interview with Mr. Smith, and he has gone out and found a new sponsor in the meantime. There were some deficiencies in the reports that I reviewed. However, after going through the interview with him, he was able to demonstrate sufficient knowledge to be licensed. So I make the recommendation that we move him up to licensed.
Mr. Walton has made a recommendation to upgrade Mr. Smith to approve his education for upgrade. Do we have a motion?
I make a motion, we accept.
We have a motion to accept from Commissioner Hall. Do we have a second?
Second.
We have a second from Commissioner Staniford. Any discussion? If not, all in favor signify by saying aye.
Aye.
Any opposed? Upgrade request granted. At this time, I would like to turn the chair over to Commissioner Hall so that I can give a report on my trainee. Oh, excuse me, my applicant, excuse me.
Mark Johnstone interviewed Mr. John Gabriel Martin, certified residential 3315, for an upgrade to CG. Mr. Johnstone, do you have a recommendation?
I had the opportunity to interview Mr. Martin, and his experience was acceptable and met all of the qualifications for an upgrade request, and I make a recommendation that he be upgraded from CR to CG.
We've heard the report of Mr. Johnstone. Do I hear a motion to that effect?
Make a motion that we accept.
Okay, a motion from Mr. Walton. Do I hear a second?
Second.
Second from Mr. Standiford. Discussion? Hearing none, all in favor say aye.
Aye.
Opposed, like sign. Motion carries. Mr. Johnstone, return it to you.
Thank you, Commissioner Hall. That concludes the education interview portion of this meeting. We're now ready for the education report, and Dr. Barilla, you are recognized, sir.
Thank you, Mr. Chairman. We have 3 courses listed here from the Appraisal Institute, 1719, Brian Reynolds, 1720, and 1721. They're all for continuing education, and I recommend 4 of those courses. There was an individual course request by Tiffany Marsh, which I reviewed also, for 30 hours continuing education. I recommend for that as well. And then there was also an addendum, course number 1722, this morning from Trees for Defensible Appraisal Practices, and I would recommend for that 7 hours continuing education as well.
Okay, you've heard the Education Committee's report for approval of education. Do we have a motion?
Make a motion that we accept.
We have a motion from Commissioner Walton to accept the recommendation. Is there a second?
Second.
We have a second from Commissioner Johnson. Any discussion on the Education Committee recommendation? If not, all in favor signify by saying aye.
Aye.
Any opposed? Course recommendations approved. At this time, that concludes the agenda items up into the lunch break. I would ask Ms. Avers where are we going to go from here? Do you want to take a quick break and start with the formal hearing, or do we need to wait till 1 o'clock, or what's the process? Oh, I'm sorry. I need my glasses. Excuse me.
Right. We could start the formal
Okay.
hearing.
Yes, I'm
Has the
sorry.
respondent or
No, I
respondent's
didn't-
counsel arrived?
I'm not sure. I've never met.
Looks like it may be a default. It's about 9:30, almost 9:30.
There will still be a fair amount of proof.
Right.
Okay, so, the meeting was to begin at 9 a.m. and the formal hearing participants are not all here at this time.
Mr. Chairman?
Yes, sir, you are recognized,
Thank you.
Mr. Hall.
If I understand our attorney correctly, there's going, even to get a default judgment, there has to be testimony
Oh, yeah.
in the
Oh,
record.
yeah.
Right.
And I'm getting the feeling that we need to go ahead and get started now to get this testimony into the record, even if it winds up being a default. Is that correct? It's up to the judge, but I mean, am I understanding the procedure?
Sure, yeah. Right. And have we received any phone calls from Respondents Council or anything of that kind? No? We could go ahead and get started.
So we could-
Unless the commission wants to take a break.
No, let me ask a question of the honorable judge. If the respondent does arrive at some point during the proof portion, will they have an opportunity to respond at the end of that, or, okay, all right. I think at this time, unless the commission wants to, let's get started with the proof portion of this formal hearing.
On this side, we want to leave this section open in case.
In case the respondent appears, right. Right. The witness could testify from the seat diagonally across here, and that way there'd be a microphone.
I simply want to make sure we had that straight.
Right.
And that way I can rock and roll.
Yeah, no, that's fine. Well, I think she's moving anyway, though. She's moving anyway.
If I can have the edge and I can rock and roll. Is there any way that the outside door will stay open when people try? Okay, I don't like trying cases with a kickstand because there's a whole lot of hallway noise. That's all.
we'll get started. Today is Monday, January 13th, the year 2014. This is a hearing conducted by the Tennessee Real Estate Appraiser Commission. The commission is chaired today by its vice chair, Mr. Mark G. Johnstone, and the commission will be considering docket number 12.36-120897A, the matter of David Harris. Mr. Harris holds Tennessee Certified General Real Estate Appraiser license number 692. Assistant General Counsel Jesse D. Joseph represents the state in this matter. It would appear that it's 9:33 a.m. This matter was set for 9 a.m. and it appears that Mr. David Harris is not here. It also appears that his attorney, Mr. John S. Anderson of the Rogersville Bar, is not present. What evidence does the state have that Mr. Harris and Mr. Anderson were notified of today's hearing, Mr. Joseph?
Your Honor, if Your Honor looks within the official file of the Administrative Procedures Division, on April the 23rd, we filed the notice of hearing and charges in this matter. And in early June of 2013, or early July, a conference call was held with the Honorable Anthony Agent, with the respondent's lawyer participating, in which the respondent had requested a continuance. And we, within that July, I think it was July the 8th, opposition to the respondent's request for continuance, we attached a copy of the certified mail notice reflecting service. Since that time, there have been 3 or 4 additional pre-hearing orders that were entered by the Honorable Judge Joyce Safley, and Your Honor, continuing the case, advising the respondent of the continuance dates. At least since October of this year, this case has been set for January the 13th. And as a matter of fact, if Your Honor looks at the August 15th, 2013 order of continuance that was entered by Judge Safley, it specifically continued the case to January 13th at 9:00 a.m. and the respondent's counsel was copied on this mailing. And there have been several orders since then that were all sent to the respondent. So the record reflects evidence of service, evidence of pre-hearing conferences by telephone with respondent's counsel, and orders of continuance that were all mailed to the respondent, advising him of the.
Right, and you've checked, and there's no phone calls of today or
Phone
anything?
calls of today, no list of witnesses and exhibits, no faxes, no notification whatsoever.
Well, I find, Mr. Chairman, that notice is legally sufficient. This commission can decide whether to proceed in the absence of Mr. Harris and his counsel, or whether to continue the matter one more time.
You've heard the evidence of service, and it is adequate. And Honorable Judge has asked that we decide as to whether this body wants to continue with the formal hearing or continue. I would entertain a motion either way.
I make a motion that we proceed.
We have a motion to proceed by Commissioner Hall, seconded by Commissioner Barilla. Any discussion on the motion to continue with this formal hearing? If not, all in favor signify by saying aye.
Aye.
Any opposed? Motion to continue approved.
Motion to continue today approved.
Yes,
Right.
yes, Your Honor.
Okay. My name is Madeline B. Williams, and I've been assigned by the Secretary of State to serve at this hearing as administrative judge. I will make rulings regarding the order of proceedings, the admissibility of evidence, and questions of law under the authority granted me by the Tennessee Administrative Procedures Act, but I will not participate in the findings of fact or the ultimate decision of this commission. Those decisions will be made by the commission members. At this time, I would ask the commission members to introduce themselves for the record, starting with the gentleman to my immediate right.
Ed Barilla, Johnson City, Tennessee.
Tim Walton, Collierville, Tennessee.
Mark Johnstone, Jackson, Tennessee.
Norman Hall, Brentwood, Tennessee.
Gary Standifer, Franklin, Tennessee.
Rosie Johnson, Paris, Tennessee.
Thank you, and there's a quorum present. Members of the commission are reminded that during the time this hearing is being conducted, no discussion of this case should take place between commission members, witnesses, attorneys, or other persons unless all parties are present. This commission sits as a jury and must only consider evidence introduced at the hearing in reaching its decision. The Sunshine Law requires that all commission discussions and deliberations be in public before all parties. Failure to observe the Sunshine Law may result in the commission's action being reversed or amended if appealed. Commission members, you should not draw any conclusions until all of the proof has been heard. Please listen to all of the proof with an open mind. Before going further, I would remind the members of the commission that the law requires you to disclose on the record any outside knowledge of this case that you may have, any outside communications, written, verbal, or otherwise, from any parties concerning this case. At this time, I would ask the state to distribute the notice of hearing and copies of the law and applicable rules. Commission members, please read the notice and see if any of you have prior knowledge of this case, of the parties, or any kind of conflict of interest with serving.
That's a no.
It's not possible.
Not this one. No. Sorry.
It could be that if you speak in a commanding way, you'd be able to be heard.
We'll do that.
That's fine. I've been told that I speak too softly, so we'll go.
It's what you prefer. We don't technically need it. Okay, great. Jesse? She asked.
She stays right there.
If you can be heard.
I will speak as loud as I can.
Judge Williams, I believe everyone's had an opportunity to review the notice of hearing and charges.
Is there anyone that has anything to disclose, any outside communications, any conflicts of interest? Anything of that kind? No?
No, Your Honor.
All right, then everyone may serve. During the course of this hearing, there will be an opportunity for each of you to question each witness that testifies under oath. Please use your questions as opportunities to gain any clarifications of the facts that you feel would assist you in reaching a decision in this matter. However, you must reserve any expression of opinion you may have to that portion of the hearing that is set aside for the Commission's deliberations after all of the proof in this matter has been heard. The technical record in the David Harris matter includes the following. April 23rd, 2013, the notice of hearing and charges. May 5th, 2013, opening letter from Administrative Judge Anthony Adjent. July 2nd, 2013, respondent's motion for continuance. July 8th, 2013, state's response in opposition to respondent's motion for continuance. July 25th, 2013, order of continuance. August 1, 2013, state's motion for continuance. August 15th, 2013, order of continuance of October 14th, 2013 hearing and pre-hearing order for January 13th, 2014 hearing. September 18th, 2013, state's motion for order compelling discovery. September 30th, 2013, order granting state's motion to compel discovery. November 1, 2013, state's motion for sanctions due to respondent's failure to comply with order or to properly answer or supplement responses to interrogatories. November 15th, 2013, order granting state's motion for sanctions. November 21, 2013, transfer order from Administrative Judge Madeline Williams. January 6, 2014, state's proposed list of witnesses and exhibits. Mr. Joseph, is the state aware of any additional documents that I failed to mention?
No, Your Honor, that sounds complete to the state.
All right, then those documents will be entered as a technical record to date. At this point, I'm going to swear in the witnesses who are going to testify. Are all of your witnesses in the hearing room at this time?
Yes, Your Honor.
Would those of you who intend to testify, please raise your right hand after me. Let the record reflect that two persons are being sworn. And I have this one question for you. Do you swear or affirm that the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
All right, the two witnesses have now been sworn. There's no need for the rule of sequestration. Any preliminary motions or stipulations, Mr. Joseph?
No preliminary motions or stipulations, Your Honor, other than, of course,
Right. All right, would you like to make an opening statement?
thank you, Your Honor. In terms of the commission, this is a case, as the commission is aware from having reviewed the notice of hearing and charges, about a certified general appraiser who appraised the subject property in Washington County 3 times between. State's proof will show that the respondent appraised this subject property, known first as Glenn Courtney's proposed condominium sites and duplex residential subdivision. Later, this subject property was known as the Stonegate proposed condominium sites and undeveloped land in September of 2009 and again in September of 2000. State's proof will also show through the testimony of the state's expert witness, Mike Orman, that the respondent committed numerous violations of USPAP in both the 2009 and the 2010 report. The property is essentially divided within a north tract, north of the railroad tracks, and a south tract, south of the railroad tracks. Specifically, our proof will show as to the 2009 report that in the respondent's site description section, that the respondent failed to identify 86 condominium sites or the 15 proposed residential duplex lots with any architectural or engineering drawings, any plans or specifications, or the included utilities and streets or the characteristics of their construction. That he failed to identify these either within the 2009 report or his work file. Similarly, in the 2010 report, the respondent failed to identify the proposed 73 condominium sites with all utilities and streets in place, failed to include such drawings, plans, or specifications sufficient to properly identify these sites or the included utilities and streets or the characteristics of their construction. In this regard, with respect to the respondent's site description, the state contends that the respondents violated standard rules 11B, 12EI, 21B, and 22B3. In the sales comparison approach, the state's proof will show, as to the 2009 report, that the respondent did not provide any discussion of how the owner's intent to remove existing improvements on land sale 1 affected the price per acre which he came up with for this property, that the respondent's claim that the subject's contract price was $40,437 per acre was on the lower end of the range for multifamily sales, without that claim had no support, and that his value indications for phase 1 and for phase 2 was unsupported by any reasoning. Furthermore, the state's proof will show as to the 2010 report that the respondent committed the same types of violations, and that in both reports, the sales comparison approach did not show whether the additional 15 multifamily land sales were similar to, or whether they were from similar market areas as the subjects. Also, the sales comparison approach did not provide any analysis regarding what the specific level of multifamily housing was addressed, and provided no information as to the proposed density levels or number of units for the sales and how such density levels compared with the subject, or whether any other multifamily sales were for projects such as apartment complexes. State believes that as to the sales comparison approach in both reports, that the respondent will have violated standard. Regarding the respondent's income approach discounted cash flow analysis, in the 2009 report, our proof will show that the respondent provided no supporting data within his report or the work file saying how he arrived at the pad value of $30,000 per pad for each condo, where he claimed that an average asking price was $150,000 for a finished total value after construction. These percentages were devoid of support within the respondent's report and his work file. The proof will show that the respondent provided no evidence in the report or work file supporting the $150,000 asking price. Further, that while the developer had started construction on 15 condominiums, had sold 2 of them, and had pending contracts on 2 to 4 others, that none of these sales, none of the pending sales of these 15 condos were included within the respondent. Proof will also show that additional problems in the respondent's income approach for the 2009 report were that he provided no support. He referred to the proposed development as the first of its kind in the area, but he failed to consider the subject's specific market along with the associated risk in this specific concept in developing his discount rate. The state's proof will also show that the respondent provided no explanation for his conclusion on the one hand that on the other hand, lot values were anticipated to increase 5% per annum for the next. The state's proof will show that the respondent committed these same types of errors and which are far more numerous to mention in this opening statement as to his income approach, discounted cash flow analysis in the 2010 report. All in all, the state contends in this report that the respondent violated standards rules 14A, 3 and 4, 21B, and 22B8 of USPAP. As to the respondent's reconciliation, the state's proof will show that the 2009 reconciliation did not present sufficient information to enable the intended user or the respondent's peers to understand his conclusions, and that in the 2010 report, the respondent did not include a reconciliation at all. Instead, in the 2010 report, the state's proof will show that the respondent used what he called an allocation of value, where he included a specific contribution for a clubhouse site, but earlier within the same report, the respondent had stated that the exact contribution to value of the clubhouse site was undetermined. As to his reconciliations, the state contends that the respondent will have violated the scope of work rule, standard rules 16A and B, and 2-2. Finally, as to the respondent's certifications, the state's proof will show that in the 2010 report, the respondent erroneously stated that the date of value was quote-unquote September 18th, 2009. Also in the 2010 report, that the respondent failed to state that he had previously appraised the property both in 2000 acceptance of the 2010 assignment. The state contends that the respondent has violated the ethics rule conduct section as to his certification. All the proof. The state submits that it will have proven all of the alleged facts and conclusions of. Despite the fact that there will be far more than 10 violations of USPAP committed by the respondent as to both appraisal reports. Despite the fact that the commission has the authority to assess a civil penalty of up to $1,000 per violation, the state submits that a reasonable civil penalty in this regard would be a per appraisal report for a total civil penalty of $2,000 for the commission to determine what additional corrective education can assist the respondent in avoiding. The respondent be required to obtain said additional education and to pay the cost of this cause and the civil penalty in full within 90 days after that his certified general certificate be immediately suspended for an indefinite cost that the state would request the commission to assess in its final order in this cause, as well as the cost of the Administrative Procedures Division of the Secretary.
Thank you for your opening statement. I believe you were just joined by two gentlemen while you were speaking. Is either of you Mr. Harris or Mr. Anderson? No? Okay, just wanted to be sure. If you call your first witness, please.
Your Honor, the state would call as its first witness Nicole Avers.
You may sit where you are, Ms. Avers, because you've got a microphone.
Address, ma'am.
500 James Robertson Parkway, Nashville, Tennessee.
And you are Nicole Avers, correct?
Yes.
Are you an employee of the Tennessee Department of Executive Director for the Tennessee Real Estate Appraiser Commission?
Yes.
Also Executive Director for various other regulatory boards and commissions and programs with the Department of Commerce and Insurance. Director for the Tennessee Real Estate Appraiser Commission.
I oversee all of the license functions, including applications and renewals. I process the complaints, and I am the official custodian of record.
You know the respondent in this case, David W. Harris.
Only as a licensee.
Do you have any bias or prejudice against him?
No.
with the complaint that was filed in this matter which resulted in this notice of hearing and charges?
Yes.
And how are you familiar with that complaint, ma'am?
I received the complaint.
Did you forward this anonymous complaint to the respondent and ask for his response?
Yes.
What is the document I'm handing you now for identification?
Letter dated January 18th, 2012, which is a notice of complaint, which includes request for 3 appraisal reports completed by the respondent and the appraisal and work files for those properties.
Who is Iman Youssef?
She is my administrative assistant and complaint coordinator.
And was this document sent by Iman Youssef?
Yes.
Do you maintain a true and correct copy of this January 18th, 2012 complaint, notice of complaint letter from your office to the respondent within your official books and records of this commission?
Yes.
Do you have a business duty to do so?
Yes.
Your Honor, we ask that this January 18th, 2012 notice of complaint letter from Mrs. Avers' office to the respondent requesting his response be admitted into the record as exhibit number 1.
Documents admitted as exhibit number 1, and you may distribute copies to the commission members.
Have you been shown, Mrs. Avers, a copy of the state's list of witnesses and exhibits filed in this matter? How were you provided with a copy of that document?
It was given to me by you.
Let's take several of the documents which are contained on this list of witnesses and exhibits together and see whether or not you can identify them together. I am now going to show you copies of the state's proposed exhibits 2 through 7. And I'm going to ask whether or not you can identify each of those documents.
Yes, I can.
And what is proposed exhibit number 2?
Proposed exhibit number 2 is dated January 26, 2012, and it's a response to the complaint from Mr. David Harris, which we received on February 1st, 2012.
What is exhibit number 3?
It is a second response dated January 26, 2012, which we received on February 1st, 2012, and this references the appraisal reports and work file documents.
What is proposed exhibit number 4?
The 2008 appraisal report of Glenn Courtney's proposed condominiums by David W. Harris.
What is proposed exhibit number 5?
The work file documents for that appraisal report.
What is proposed exhibit number 6?
The 2009 Glenn Courtney's proposed condominiums appraisal report by David W. Harris.
What is proposed exhibit number 7?
The 2010 Stonegate proposed condominium appraisal report by
Receive each of the documents that have been marked for identification as proposed exhibits number 2 through 7 within your office as executive director.
Yes, we received them all on February 1st, 2012.
Do you maintain true and correct copies of those documents within your official complaint file in this matter against the respondent?
Yes, I do.
Have a business duty to so maintain those documents.
Yes, I do.
As testified and authenticated and identified by Mrs. Avers, be admitted into the record.
Exhibits 2 through 7 are admitted into the record at this time, and you may distribute copies to the board, to the commission members also.
Avers, do you know who the anonymous complainant was in this matter?
Let us submit anonymously now.
Is the respondent David W. Harris certified as an appraiser with this commission?
Yes, he is.
And what type of certification does he possess?
Certified general.
And when was he first certified as a certified general appraiser by this commission?
December 31st, 1991.
What is his certification number?
692.
And when does the respondent's certification expire?
December 31st, 2015.
According to the books and records of the commission, what is the respondent's last known mailing address?
Route 3, Box 1078, Jonesville, Virginia, 24263. Although on his last renewal, I did make note of 2 different addresses on his continuing education certificates, which I made.
Filing of the notice of hearing and charges in April of last year.
Has filed no change of address forms.
Thank you.
Commission members, this is your opportunity to ask questions of the state's first witness.
Chairman,
Yes, Commissioner Burlow?
In Exhibit 2, there's reference made here to Mr. Bailey, who I know rather well, and he does work for me at different times. And I'm wondering if continuing on in this might, I don't know the legal situation, but might, I don't know, poison the judgment or whatever, because I do know Mr. would leave this proceeding based on question of the anonymous complaint and where it came from. But I do know Mr.
So, Commissioner Barilla, are you indicating that you may have a conflict of interest due to a relationship with Mr. Bailey that would not allow you to be an
Well,
unbiased participant?
I don't know what you're asking, except he does work for me. I know Henry well, you know, and I can be impartial, but whether an outside observer looking at it might look at it and say, how could I be impartial? That
I would ask counsel, can I ask counsel a question? Would that be, with that relationship from an outside source looking in, does that appear to be a conflict that could inhibit the state's position upon appeal?
Well, Your Honor, and members of the commission and Commissioner, so if you look at Exhibit Number 2 is a letter from the respondent. As far as I'm concerned, the state has no proof as to who submitted the complaint.
No reason to believe that it was submitted by Mr. Bailey.
Right, well, certainly you've noted the potential conflict for the record, which is important.
There's no evidence to whether Mr. Bailey was involved or not, according to Director Avers. So that's there's no verification one way or another. And thank you for pointing that out on the record. Commissioner Hall, you're recognized.
Don't know whether I have a quote conflict of interest, but I know Henry Bailey. I served on the Real Estate Appraisal Commission with Mr. Bailey. I also know Mr. David W. Harris through his professional organizations. So I reckon I know both, i.e. parties that are mentioned in that letter, the writer and the person being accused. Now, the question is, can I sit here objectively and answer or try to shift through the data that will be presented? That is the question. Judge?
That is the question. So you know Mr. Harris?
Yes, I do.
Okay.
I've known Mr. Harris professionally for probably about 30 years, and I've known Mr. Bailey since we served on the commission together. And whether or not Mr. Bailey is actually involved or not, I do not know. I have no knowledge of that. But I don't want anybody to think that I know one party or the other, and therefore my decision was based on that information.
Mm-hmm.
And I don't want this commission to be tainted with any type of information or about if I favor the complainant. You might say you favored Henry Bailey. If I go with Mr. Harris, they're going to say, well, you're just a friend of his. I don't know whether or not the perception, well, regardless of what I do, I just don't want the perception to be there that something was not correct with the decision of this commission. So I think I'm going to recuse myself.
If you recuse yourself, sir, then the commission would have less than a quorum.
5 is the quorum.
It's 5 or is it 6 as the quorum?
I do believe that they can have a commission. Still have 3 appraiser members remaining.
Okay.
We would have 3 appraiser members
Okay.
and barely make a quorum.
Okay. All right, then, sir, you are recused.
Thank you.
Questions for Ms. Avers?
Not from me. Any other board members have a
Pardon me,
question?
I
for
might,
Ms. Avers?
do you have an idea how long this, I noticed there's other items on the agenda that I could return for if you would like to. 1 o'clock? You have my cell phone, do you not, Ms. Evers?
Why don't you give that to me?
Open, public. Okay, thank you. I don't want my admirers calling me on the phone.
If there's no questions for Ms. Avers, then your next witness, please, Mr. Joseph.
Commissioner
Oh, well, wait a
Standiford has a question.
minute. Okay.
Just like it to be known that I do know Mr. Harris, and I do know Mr. Bailey.
I'd just like to point out for the record that we don't have any evidence that Mr. Bailey's really. I
Right,
want that to be clear.
right, such is noted for the record.
I'll go on and make a statement as well. I do not know either one of these individuals. However, I am a member of the Appraisal Institute, of which the respondent is a member, but I've never met him.
Oh, your next witness,
Your Honor, the
please.
state will call as its next witness Mike Orman.
Judge, can we have a 5-minute break for the restroom, please?
Sure,
Prior to this testimony?
sure, certainly,
Thank you.
certainly.
Could you please?
Michael T. Orman, O-R-M-A-N.
Mr. Orman, before we begin, could you look at the documents that you have in front of you and ensure that you have exhibits 1 through 7?
Yes, sir, I have.
You are a certified general appraiser in the state of Tennessee, sir, correct?
Yes, sir.
And when were you first certified in Tennessee?
October of 1991.
Are you certified or licensed as an appraiser in any other states?
Yes, sir, I hold a certified general license in the state of Arkansas, state of Mississippi, and the state of Oklahoma.
What is your business address, Mr. Orman?
2989 Elmore Park, Bartlett, Tennessee.
Do you have any other professional licenses or certifications issued through this department?
Yes, sir, I hold a Tennessee broker's license.
Is it currently active?
Yes, sir, it is.
Are you presently under contract with this department to provide both residential and non-residential appraisal reviews and expert testimony and in certain complaints that are assigned to you that are
Yes, sir.
prepared a current qualification sheet, or what I call a curriculum vitae, which sets out your qualifications?
Yes, sir.
Document which I'm showing you now, a copy of your qualification sheet?
Yes, sir, it is.
And did you prepare that?
Yes, sir, I did.
Is it true and correct?
I'd like to make one alteration to number 5. I have retired my Mississippi broker's license.
All right, sir. Other than that alteration, is this qualification sheet true and correct?
Yes, sir, it is.
Your Honor, we would ask that Mr. Orman's qualification sheet or curriculum vitae be entered into evidence as exhibit number 8.
All right, it's entered as exhibit number 8, and you may publish it to the commission members.
All right, Mr. Orman, according to your curriculum vitae, are you a member of the appraisal selection roster for the Department of Housing and Urban Development?
Yes, sir, I am.
What does that entail?
It allows me to do FHA appraisals.
According to your qualification sheet or curriculum vitae, which you have entered into evidence as exhibit number 6, you are also an approved VA appraiser, correct?
Yes, sir.
And what does that entail?
I mean, I've met the requirements to do VA appraisals.
And you are a member of the National Association of Independent Fee Appraisers, which is abbreviated NAIFA, correct?
Yes, sir, I am.
What is NAIFA?
It is a national appraisal organization, one of the founding members of the appraisal.
1998, according to your qualification sheet, you were awarded the Independent Fee Appraiser Senior IFAS designation, correct?
Yes, sir, I was.
And what does that designation represent?
It represents the amount of education and work product that I've put out. In 1993, I got my IFA designation, which was toward residential, and the IFAS, which is Independent Fee Appraiser Senior, indicates that I've met the education and the work product requirements to get a commercial designation.
And you've been an officer of NAIFA for several years, correct?
Yes, sir. I ran the chair for the national organization and was president in 2008.
Are you a general accredited appraiser and a residential accredited appraiser?
With the National Association of Realtors Appraisal Section, yes, sir.
What do those designations mean?
Indicating that certain proficiency levels have been met to earn those designations through the National Association of Realtors.
CRP mean on your qualification sheet?
That is a certified relocation professional through the Employee Relocation Council. Again, it was a certain amount of education and testing required to attain that designation.
What are the abbreviations GAA on your qualification sheet represent?
General Accredited Appraiser through NAR.
What do the abbreviations ASA on your qualification sheet represent?
American Society of Appraisers. I hold the senior designation through the American Society of Appraisers, which is, again, a founding member of the Appraisal Foundation.
Taught continuing education courses for appraisers in Tennessee and in other states.
Yes, sir, I have.
What courses have you taught? What courses do you teach and for what providers?
I've taught for National Association of Independent Fee Appraisers, all their residential and commercial courses that are available. I've taught a USPAP course for NAIFA, USPAP courses for NAIFA. I've also taught some for ASA, USPAP. I have taught for Southwest Tennessee Community College, taught the residential courses in USPAP, and I've taught for the University of Memphis as adjunct faculty, residential courses and USPAP.
What is a certified USPAP instructor, sir?
The Appraiser Qualifications Board sets out requirements for a person who's going to teach a uniform standards professional appraisal practice, and they set out the requirements necessary, and they started to give a certification to those instructors who meet those requirements.
Are you a certified USPAP instructor?
Yes, sir, I am.
And how long have you been a certified USPAP instructor?
Since 2002.
Do you teach USPAP to appraisers in Tennessee?
Yes, sir, I do.
Do you teach USPAP to appraisers in any other states?
Yes, sir, I do.
What states?
Oklahoma, Arkansas, Mississippi, Alabama, Georgia, and I believe that's pretty much all of them.
Have you ever been disciplined by this commission, Mr. Orman?
Yes, sir, I have.
When did that occur?
I had a complaint filed in 1993.
What were the circumstances which brought that disciplinary sanction about?
I had a complaint filed on a appraisal report that I had completed, and the commission or the state filed a complaint on an appraisal report I signed about the same time as a review appraiser for one of my staff.
And was the consent order entered in this case in February of 1995?
Yes, sir, it was.
Was your certified general certificate suspended by that order?
No, sir, it was not.
What were you required to do as a consequence of entering into that order?
I was required to take 4 classes and submit 2 additional reports.
What were the nature of the classes you were required to complete?
The classes was an income class, a USPAP class, a condemnation class, and a narrative report writing class.
And when did you obtain that additional continuing education?
Finished that education. I was asked to do that in February '95. I actually completed that in May of '95. I actually completed 7 classes by May of '95. I took more education than required by the state.
Did you fully comply with the consent order which you signed in February of 1995?
Yes, sir, I did.
What was the nature of the problems that the commission found with your appraisal reports 19 years ago in that consent?
There were USPAP violations that they found.
What have you done with your career over the last 19 years after having received that consent order?
Made changes. That was an eye-opening experience. I knew that if I was going to be a part of this profession, that I had to educate myself and become educated. The commission allowed me an avenue to educate myself and become a better professional, better appraiser. Since then, I've become designated with 2 organizations. I've become an instructor throughout for our national appraisal organizations. I continually try to educate myself, and it's one of the better things that ever happened in my career.
Have you received any further disciplinary sanctions, Mr. Orman, after this 1995 consent order?
No, sir.
Have you been disciplined by any other state's appraiser disciplinary agency?
No, sir.
Within this February 1995 consent order, how many months were you restricted from performing appraisals requiring a certified general license?
There wasn't a time I had to finish those 4 classes, which February to May, some 3 months.
Have you ever had a court judgment entered against you or a settlement in any court case where you were found to have committed professional negligence, malpractice, or breach of your duties as an appraiser?
No, sir, I have not.
Was the disciplinary sanction that was entered against you by this commission 19 years ago, did that involve fraudulent or intentionally misleading conduct?
No, sir.
Ever written any articles in the field of real estate appraisal?
I've written one article for Mobility Magazine in the mid-'90s dealing with the automated valuation models, AVMs.
Approximately how many years ago was that?
Like I said, mid-'90s, you're probably talking about almost 20 years ago.
Have you ever been accepted as an expert witness in real estate appraising before this commission?
Yes, sir, I have.
How many times?
Numerous. Over 20.
Before this commission?
Oh, I'm sorry. No, sir, I apologize. This commission, I think this is the 3rd or 4th time.
All right, sir. Have you ever been accepted as an expert witness in real estate appraising and proceedings pending before any other state's appraisal boards?
Yes, sir, I have. I testified for the state of Oklahoma.
How many times?
Once.
Have you ever been accepted as an expert witness in real estate appraisings in any court cases in Tennessee?
Yes, sir, I have.
How many times?
That would probably be over 20.
What were the nature of those cases?
They varied anywhere from marital dissolution, partnership, probate, just various types of litigation.
Have you ever been accepted as an expert witness in real estate appraising in court cases in any other states?
Yes, sir, I have. The state of Mississippi and the state of Arkansas and the state of Oklahoma.
Approximately how many cases?
4.
Have you prepared a list of your prior testimonies and depositions that you have given as an expert witness over the past 5 to 10 years by listing the subject property address?
Yes, sir, I have.
Is the document which I'm showing you now a copy of that list of testimonies and depositions which you've given?
Yes, sir, it is.
Did you prepare this document?
Yes, sir, I did.
Is it true and correct to the best of your knowledge and information?
Yes, sir.
Your Honor, we ask that Mr. Orman's list of court testimonies and depositions be entered into evidence as the next numbered exhibit, which would be exhibit number 9.
Right. The document's entered as exhibit number 9, and you may publish it to the commission members.
You ever work as an appraiser, Mr. Orman, in Tennessee before licensing occurred in the early 1990s?
Yes, sir, I did.
And when was that?
I began working with my parents in the early 1980s, 1982.
And that was for statewide appraisal service?
Yes, sir, it was.
And after you obtained your certified general certificate, what did you do next in your practice?
I tried to grow my practice and just doing all types of appraisals. Got into management and review over offices also.
Do you own your own appraisal business now?
Yes, sir, I do.
How many employees do you have?
Right now, I have 6 employees in Memphis, 2 in Arkansas, and that's it. Yeah.
What is your area of concentration, Mr. Orman, as a real estate appraiser?
We do all types of properties. I do a lot of the litigation, commercial, and the review.
Approximately how many non-residential real estate appraisals would you see you completed during your career?
Hundreds. Thousands.
What is an appraisal review, Mr. Orman?
Appraisal review is to investigate the quality of another's work.
Have you ever prepared appraisal review reports from the field?
Yes, sir, I have.
Approximately how many?
Probably a few hundred of field review appraisals.
What is a review from the field?
It's actually where we go out and do a street observation of the property and any of the sales or information is provided. We try to do a street observation or field observation of the information.
Have you in fact prepared appraisal reviews from your desk?
Yes, sir, I have.
Approximately how many?
Probably 25, 30.
Are the types of reports that you prepare from my office, the Office of Legal Counsel for the Tennessee Department of Commerce and Insurance, an appraisal review report which you prepare from your desk?
Yes, sir, they are.
Are you familiar with the Uniform Standards of Professional Appraisal Practice, Mr. Orman, which were in place between 2008 and 2010?
Yes, sir.
And how are you familiar with them, sir?
As a practicing appraiser is part of being a practicing appraiser, but also as a USPAP instructor.
Your Honor, on the basis of this witness's education, training, and experience, we would tender the witness.
Gentleman is recognized as an expert.
Mr. Orman, could you please explain, insofar as your methodology is concerned, what your general practice is for conducting an appraisal review report as requested by my office?
Basically what happens is I receive information from the state. Normally that information includes communications from a respondent. I might get a copy of the complaint, get a copy of the response. I get a copy of any appraisal reports or documents that's sent into the state. Then I will get any documents, a copy of the appraisal, work file information that is sent in by the respondent, and all that information is sent to me. Once I get that, I take some time to kind of go through and see what I have before I start my review. Once I've got an idea of what information I have, then I go through the review process.
What are the types of data, Mr. Orman, that you customarily rely on when you prepare an appraisal report from your desk?
A lot of online services such as courthouse retrieval services, CRS, might utilize MLSs depending on the areas that we're in. Any courthouse information, local assessor's office information, any information I can probably get online or either call and try to get.
Are these the types of data that appraisers would generally use when conducting an appraisal review from the desk?
Yes, sir.
Now, Mr. Orman, before you formulated your opinions in this case, which you provided to my office, do you always review and read the respondent's written response?
Yes, sir, I do.
Before you formulate your opinions, Mr. Orman, which would be contained in your appraisal review reports, do you always review the work file documentation which the respondent has provided to the office of Mrs. Avers?
Yes, sir, I do.
Before you sent in your appraisal review report, Mr. Orman, to my office, did you read the respondent's response and his letter describing his work file contents?
Yes, sir.
Did you take into consideration in formulating your opinions the arguments and reasoning of the respondent, which were included in his written response?
Yes, sir.
Now, Mr. Orman, during 2012, did my office ask you to conduct an appraisal desk review and prepare an appraisal review report of the respondent's appraisals of the Stonegate proposed condominium sites and undeveloped land in Washington County, Tennessee, which are involved in this case?
Yes, sir.
And you did that?
Yes, sir, I did.
And Mr. Orman, did my office pay you, sir, for your time
Yes, sir, they did.
in preparing this review?
Yes, sir.
What is your approved rate of pay pursuant to the contract that you've entered into with the state?
$1,200
And that is for what?
for the review, of commercial or complex properties, commercial properties.
And what is your rate of pay with respect to other aspects of your preparation, such as testifying in this case?
Contract with the state is $200 an hour.
Are you paid by my office as your client only in cases in which you have found violations?
No, sir.
Have there been any complaints in the past, Mr. Orman, that you have reviewed in which you found no violations?
I have done several with no violations.
Do you know how to approximate how many?
It would be a guess. Probably 4 or 5, or more. Yeah.
Do you know the respondent in this case, Mr. Orman, David W. Harris?
Not to my knowledge, no, sir.
Do you have any basis to harbor any bias or prejudice against him?
No, sir.
Did you personally inspect this subject property in Washington County, Tennessee, Mr. Orman?
No, sir, I did not.
You ever performed, strike that. During your appraisal desk review in this matter, Mr. Orman, did you visually inspect from any of the respondent's comparable sales?
No, sir, I did not.
In preparing your appraisal desk review for my office, Mr. Orman, did you personally visit any tax assessor's office or register of deeds offices?
No, sir, I did not.
In preparing your appraisal desk review for my office, Mr. Orman, did you reach your own independent opinion of value regarding the subject property?
I did not put a value on these reviews.
Were you obligated pursuant to your scope of work for my office to provide an opinion of value in this review?
No, sir. The scope of work is more on compliance review. Where opinion and value might come into play is if there's insufficient information within the reports that reduces the credibility of the value opinion, it may be presented, but I did not put a specific value.
In order for you to produce a credible opinion contained within your appraisal desk review report, Mr. Orman, should you have been required to do any of those things, such as render an opinion of value, personally inspect sales visually, or visit any register of deeds or tax assessor's office?
No.
Why not?
Doing a desk review, I'm looking at the quality of another's work, and based on the information I'm getting from the respondent, I'm getting their appraisal and their work file. And part of the use map indicates that their work file should be sufficient enough for a reader to formulate at least a summary appraisal report on these reports.
Copy of the document which I'm showing you now, a copy of the appraisal review report that you provided from my office in this matter?
Yes, sir, it is.
Your Honor, we would ask that Mr. Orman's appraisal review report provided to the Office of General Counsel be marked and entered into evidence as Exhibit Number 10.
The exhibit is entered as Exhibit Number 10, and you may publish it to the commission members.
Orman, I'm now going to be asking you certain questions, several questions about the substance of your opinions, which are found within your appraisal review report, which is Exhibit Number 10. Do you have that before you?
Yes, sir, I do.
also be referring as well to the respondents' reports primarily of 2009 and 2010, which are Exhibits 6 and 7, and to the respondents' work file, which is Exhibit 5, and the respondents' 2008 report, which is Exhibits 4. Do you have all those documents before you?
Yes, sir, I do.
Let's look at your appraisal review report, Mr. Orman, Exhibit number 10. Turning first to pages 4 and 5 of your appraisal review report, Exhibit number 10, and the respondents' 2 reports, which are Exhibits 6 and 7. How did you find the subject site to be divided?
I found that the property, the north parcel, or excuse me, the south parcel was to be a 7.9 acre tract, and the north parcel was 9.877 acre tract that was divided by railroad tracks.
What evidence can you point to in the way of an attachment to your appraisal review report, Exhibit 10, which supports the fact that the south parcel was 7.9 acres?
If commissioners look at the exhibit of my report, you will find on page 13 in the back of attachment number 1, there is at the top right-hand corner, it'll tell you that it has 7.9 acres, shows the acreage of that parcel.
Where did you get that attachment, sir?
I've got that from the CRS Courthouse Retrieval Services.
How many acres in his appraisal report respondents state that the south parcel contained?
6.423.
Respondent make that statement both in Exhibit 6 and Exhibit 7?
Yes, sir, he did.
According to your appraisal review report, Mr. Orman, how large was the parcel north of the railroad tracks, which we will refer to as Phase 2?
That parcel is 9.877 acres.
According to the respondent's appraisal report?
No, sir, that was according to the information I found in CRS. If you look on my exhibit, that's going to be page 15, about the center of the acreage is 1021. Shows it to be 10.21 acres there.
How many acres did the respondent within his appraisal reports, Exhibit 6 and 7, state that this north parcel was?
Sorry, the respondent shows 9.877. My report showed 10.21.
Arrive at an understanding during your review which would account for these size differences in these parcels?
No, sir, the only thing that I could figure is that the difference in between these parcel sizes was attributed to the development of the project.
Did you find a violation of use PAP as to that narrow issue?
No, sir, not really to that narrow issue because it was just not understandable.
Let's look at pages 5 through 6 of your appraisal review report, which is Exhibit number 10.
Yes, sir.
Site section. Now, where, Mr. Orman, do you find that the respondent indicated in his 2009 report, which is Exhibit number 6, that there were 86 slabs in the south parcel ready for construction?
Look on page, it's the second page of the exhibit shows 86 condo pads. And also, which the numbering of his appraisal was confusing because it had number 22 on the bottom of that page. And then if you go to page 11, I believe.
All right, sir.
I have the right, yeah. On it's page 1 of both reports it shows.
All right. Where do you find within the respondent's 2009 report, which is Exhibit 6, that the respondent stated that 2.5 acres out of the 6.423 included within the south parcel was going to be deducted from the valuation?
In the 2009 report, it's on page 2 at the bottom. Bottom paragraph.
Now, with respect to the north parcel, where do you find within the respondent's 2009 report, Exhibit 6, that the respondent indicated that this north parcel had 15 residential duplex lots and that only 8.423 of this north parcel was considered?
That is on page 3, second paragraph, showing the 8.423.
What was your opinion about seeing the 8.423?
I didn't know where it came from. I didn't understand what, it was insufficient information to determine where that size came from.
Do you find anywhere else within Exhibit number 6, which is the respondent's 2009 report, where respondent later stated that the full 9.877 acres of the north parcel was being valued?
Yes, sir. I believe that is going to be on page 12 of that exhibit of the 2009 report, and it's about mid-page.
What does the respondent say there?
It's 9.877 acres times $50,000 per.
Did you find any information within the respondent's report, Exhibit 6, or his work file, of any architectural, engineering, drawings, specifications, plans, or any other documentation sufficient to identify the proposed 86 condominium sites in Phase 1?
No, sir, I did not find any supporting documentation.
Did you find within the report or the work file, which are Exhibits 6 and 5, any such architectural or engineering drawings, specifications, or plans sufficient to identify the 15 proposed residential duplex lots in Phase 2?
No, sir, I did not.
Did you find any information within the respondent's report, Exhibit 6, or within his work file, Exhibit 5, sufficient to identify the included utilities, streets, or the characteristics of their construction?
No, sir, I did not.
What is your opinion, Mr. Orman, regarding whether the respondent complied with applicable provisions of USPAP as to his description of the site, description of proposed site improvements, and physical characteristics of the property?
I found that comments were confusing and not consistent, which led to violations of USPAP. Those violations would be Standard Rule 1-1B, Standard Rule 1-2EI, comments line 518, 5 through 520, and then Standard Rule 2-1B and 2-2B. And if I shall, I can read exactly what those are.
A brief summary would be sufficient, Mr.
All right, the
Orman.
1-1B deals with not commit substantial errors of omission or commission. The standard 1-2EI deals with an appraiser and developing a real property appraiser. An appraiser must identify all those characteristics that are relevant to the property type, including its location, physical and legal and economic attributes. Also on comment lines 518, 520, which is on page U18 of the USPAP, it indicates, I need to get my right book, indicates that when an appraiser proposed improvements, an appraiser must examine or have available for future examination plans, specifications, or other documentation sufficient to identify the extent and character of the proposed improvements. 2-1B is in relation to an appraiser, 2-1B is appraiser must report must contain sufficient information to enable intended users of the appraisal to understand it properly. And then 2-2B3, which is summarize information sufficient to identify the real estate involved in the appraisal, which was not done.
And an appraiser must do all those
And an
things?
appraiser must do those things.
Mr. Orman, generally, before we continue on, what do your citations of USPAP contain within your appraisal review report packets mean, sir?
These are violations that I found within the review.
Let's remain on page 5 of your appraisal review report, which is exhibit number 10, Mr. Orman.
Yes, sir.
And looking at the respondent's 2010 appraisal report, which is exhibit 7, where do you find that the respondent assumes that phase 1, which is the south parcel, will have 73 condo pads with all utilities and streets in place, and that the development was in the process of developing the site for residential condos, with each condo pad to measure 30 by 50?
I believe that is going to be on page 11 of his 2010 report. Excuse me. It's about indicated cost of phase 1 development. It shows 73 proposed condominium sites. And then looking down, proposed development phase 1, it shows that there'd be 30 by 50 sites.
And this is within exhibit number 7?
Yes, sir. Exhibit number 7, page 11.
Where do you find within exhibit number 7 that the respondent valued the 9.8877 acreage north parcel as undeveloped acreage?
That's on page 15 of the report. He shows 9.877 acres at 40,000 per acre.
Did you find within the respondent's 2010 appraisal report, which is exhibit number 7, or within his work file, which is exhibit number 5, any architectural drawings, specifications, plans, or other documentation sufficient to properly identify the 73 condo sites in phase 1?
No, sir, I did not.
Did you find within the respondent's report, exhibit 7, or within his work file, exhibit 5, that the respondent provided any specifications, plans, or other documentation, engineering drawings, etc., to describe the included utilities, streets, or character of their construction?
No, sir, I did not.
Do you have a problem with that?
Yes, sir, I do. With, again, the same use map violations I found in 2009 report, in the 2010 report, there's insufficient information for a reader to understand what the proposed improvements are, what the utilities are going to be, how this proposed complex is to be finished out.
Go now to the sales comparison approach section of your review on page 7 of exhibit number 10. Also be looking first at the respondent's appraisal report from 2009, which is exhibit number 6. All right, let's look on page 10 of exhibit number 6, which is the respondent's 2009 report, Mr. Orman. Do you find on page 10 that the respondent provided any analysis of how the owner's intention to remove the existing improvements on land sale 1 affected the price per acre of $40,437?
No, sir, I did not.
What was, on page 10 of exhibit 6, what was land sale 1?
Land sale 1 was the subject property.
Did you find any such discussion of how the owner's intention to remove those existing improvements? Did you find any such discussion in the respondent's work file, exhibit number 5?
No, sir, I did not.
Did you find any support for the respondent's statement on page 12 of exhibit 6 that the purchase contract of the subject property at $40,437 per acre was at the lower end of the range of multifamily land sales in the area?
No, sir, I did not. He was stating an opinion as to a reference, and there was no support for that reference of value.
Where can you point the commission to the location for the quote-unquote detail sheets of the 15 multifamily land sales?
Detail sheets were in the exhibit number 5, which was his work file.
Did you find, Mr. Orman, any reasoning or analysis to support within his report or his work file the $480,000 value the respondent came up with for phase number 1 and the $500,000 value he came up with phase number 2, as found on page 12 of exhibit 6?
No, sir, I did not.
What is your opinion regarding whether the respondent complied with applicable provisions of USPAP in the sales comparison approach regarding the 2009 report?
It appears that the respondent's report does not support the opinions and conclusions provided, and that has not recognized proper techniques in completing a sales comparison approach and found violations of USPAP. And those violations are SR 1-1A, Standard Rule 1-4A, Standard Rule 2-1B, and Standard Rule 2-2B8 in USPAP 2008-2009.
Were the 480,000 valuation figure and the 500,000 valuation figure as found on page 12 of Exhibit 6, were those rounded figures or actual figures?
They were rounded figures.
Let's now look at the top of page 7 of your review report, which is Exhibit 10. Focusing on the respondent's 2010 report, which is Exhibit 7. Page 9 of Exhibit 7, which is the respondent's 2010 report. Does the respondent provide any analysis of how the owner's intention to remove the existing improvements affected the price per acre?
No, sir, it does not.
Is this the same problem that you just noted in the 2009 report?
Yes, sir, it is.
Did the respondent provide any analysis or explanation on page 11 of Exhibit 7 of how the price of $40,437 per acre was at the lower end of multifamily land sales in the area?
And there was insufficient or no information provided on this value room.
Did you find any discussion within his work file on this issue?
No, sir, I did not.
Is this the same issue you just testified to regarding the 2009 report?
Yes, sir, it is.
On page 15 of Exhibit number 7, which is the respondent's 2010 appraisal report, did the respondent provide any support or analysis for the $40,000 per acre?
No, sir, there was no support for the $40,000 per acre.
Support for the respondent's valuation of $400,000 for that 9.877 acres of the North Tract?
No, sir, there was no support.
What is your opinion regarding whether the respondent complied with applicable provisions of USPAP regarding this issue in the 2010 report?
The same issues that apply in 2009. There's insufficient information for an intended user or reader to understand the report properly, or to support the indications and conclusions that were placed in the report. And those same standard rules that I read off, SR 1-1A, SR 1-4A, 2-1B, and SR 2-2B8 would all apply out of the 2010-2011 USPAP.
At about the middle of page 7 of your review report, which is Exhibit number 10, beginning with the words "reading through," what are your overall conclusions regarding the respondent's sales comparison approach in both his 2009 and
Actually, that found no analysis reading that would support the opinions and conclusions offered.
Okay, Mr. Orman, we'll go now to the income approach dash discounted cash flow analysis section of your review at pages 8 through 9 of Exhibit number 10. Discuss that next. We'll start with page 9 of your review, and we will be looking at the respondent's appraisal report prepared in 2009, which is Exhibit number 6. Where do you find, Mr. Orman, page 12 of Exhibit number 6, that respondent indicates the estimated developer's cost for the 86 condos in phase 1 would be $20,000 per pad site, or $1,720,000.
That is about 2/3 of the way down on that page, on page 12 of that exhibit.
Further, where do you find in exhibit number 6 that the respondent uses a pad value of $30,000 for his income approach analysis?
Over on page 13, there was, this, for purpose of this analysis, a pad value of 30,000 is being used. That's going to be about mid-page, about the 5th paragraph.
How did the respondent derive this land cost of $30,000 per pad?
Made the assumption typically, to quote the report, typically land costs will approximate 20 to 25% of total value. He said the average asking price for this price of condos in this development would be $150,000. So applying the math indicated a pad value of $30,000 per pad.
Find within Exhibit 6, which is the respondent's 2009 report, or Exhibit 5, which was his work file, any support for the $150,000 average asking price of condos in this development?
No, sir, I did not.
Did you find within Exhibit number 6 or the respondent's work file, Exhibit number 5, any support for the respondent's conclusion that the typical land cost would approximate 20 to 25% of the total value after construction of a residence?
No, sir, I did not.
And where do you find within Exhibit number 6, which is the respondent's 2009 report, that the respondent claimed that the developer had started construction on 15 condominiums, had sold 2, and had pending contracts on 2 to 4?
It's going to be the 2nd paragraph of page 14 of this report.
Find any of these 15 condominium sales or any of the pending condo sales anywhere within the respondent's report, Exhibit 6, or within his work file, Exhibit number 5?
No analysis information was provided. No, sir, there was nothing in there.
Did you find any support for the indicated site value in the income approach?
No, sir, I did not.
What is your opinion regarding whether the respondent complied with USPAP in this regard?
The respondent failed to provide sufficient information, and therefore there would be violations of the USPAP.
September 18th, 2009 report, what are your citations of USPAP that is violated?
Due to the lack of supporting data, we have Standard Rule 1-1A, Standard Rule 1-4C3 and 4, which I have not cited. -1-4 in development, real property appraiser must collect, verify, and analyze all information necessary for
A
credible.
little bit slower,
Yes, ma'am.
thank you.
In developing a real property appraiser, an appraiser must collect, verify, and analyze all information necessary for credible assignment results. When the income approach is necessary for credible assignment, the appraiser must, number 3, analyze such comparable data as are available to estimate the rates of capitalization, rates of discount, and number 4, base projections of future rent, income, potential expenses on reasonably clear and appropriate evidence. And we also had a violation of Standard Rule 2-1B and Standard Rule 2-1B8.
What was the discount rate that respondent used for the forecasted sales?
Indicated 12%. That's on page 15 of the report. Excuse me. I think it's. Yes.
Is that on page 14 of the report
14.
instead of 15?
The owner expenses are 14, the discount rate's 15.
Find any data, explanation, or analysis specific to this proposed development supporting this discount rate?
No, sir.
Where does the respondent contend in Exhibit 6 that the proposed development of Phase 1 for 86 condominiums was the quote-unquote first of its kind in the area?
Sorry, I had that marked here. Okay, I'm sorry, it's page 13 of that report. It's midway, about the fourth paragraph, and indicates that this is the first of its kind.
Did you find that the respondent appropriately considered the subject specific market along with the associated risks in this concept in developing his discount rate?
No, sir, I did not.
Why not?
None of that information was provided.
Where does the respondent state within Exhibit 6, his 2009 report, that quote-unquote demand was weak to declining for all classes of real estate?
On page 14, third paragraph, there are signs of a weak recovery and indicating that that this will be increasing trend. Above that, in the paragraph above that, it indicates a weak position in the market.
Where does he state in the same exhibit, Mr. Orman, that lot values were anticipated to increase 5% per annum for the next 5 years?
That's on page 14, about 2/3 of the way down.
Find any rationale, data, or other analysis supporting the conclusion that the lots would be expected to increase 5% per annum during the time period estimated to sell the lots?
No, sir, I did not. It actually was confusing. One minute the report tells me how weak the real estate market is, and then all of a sudden we get a 5%, indicating a 5% increase in lot values over the next few years.
What is your opinion regarding whether he complied with applicable provisions of USPAP on this issue?
It was failure to comply with USPAP.
Would these be the same citations that you just testified regarding in the income approach discounted cash flow analysis?
Yes, sir.
Let's look at Phase 2, which is the north parcel in the respondent's Exhibit 6. Where does the respondent state that the 15 residential duplex lots should have a per lot value of between $32,000 for a single family lot and $64,000 two lots?
Page 17 of the report, it's about 2/3 of the way down.
Where does the respondent state in Exhibit 6 that the developer's estimated cost for the duplexes was $43,150 per lot?
That was the second paragraph, same page 17.
And where can you point the commission within Exhibit 6 that the respondent used an average value of $50,000 per duplex in his analysis? And where does the respondent state that he used no discounting adjustment as to these lots?
Over on page 17, again, two-thirds way down, it's about the sixth paragraph. So for the purpose of this analysis, a duplex lot has an average value of $50,000. And second question.
Where does he make a statement that there was no discounting as to that?
That was on page. It's on page 18 at the top of the page. It's the second sentence, basically.
Find any alleged violations of use PAP in this regard?
Yes, sir, it did.
Are those the same citations that you have just previously testified to?
Yes, sir, they are.
Let's go to the respondent's last question before I go to the next section. Where do you find that the respondent stated as to these duplex lots that these lots were expected to sell within a year?
Again, on page 18, top paragraph, first paragraph.
Did you find any support for those conclusions?
No, sir, I did not. I actually found information within the report that would indicate longer than that. And they were talking about extended periods of sales times, years.
Let's go to the respondent's 2010 report, exhibit number 7. Where is it stated by the respondent in exhibit number 7 that only 73 condo sites are included within phase 1?
If you'll look on the second page of the transmittal letter, it shows the condo sites 49 and 24. And then on page, I believe it says it again on page 11.
Where is it stated within exhibit number 7, which is the respondent's 2010 appraisal report, that the estimated development cost was $20,000 per pad and that the respondent used the same $30,000 per pad value in this report that he used in the 2009 report?
I believe that's on page 11 also.
What did the respondent base his $30,000 per pad value on, and what was the average asking price for these proposed condos in the 2010 report?
And the respondent over on page 12 indicated that 30,000 pad value was based on what the potential asking price of 150,000 for the condos, and then applied a mathematical formula using 20 to 25%.
Is this the same as previously testified on regarding the 2009 report?
Yes, sir, it is.
Did you find any discussion which respondent provides in exhibit 7 on a competitive condominium property named?
Yes, sir, it did on page 12. It's under the title estimated time period to market. It's the first paragraph, last sentence.
What does the respondent have to say about condominium sales in Kensington condos in 2010?
They're priced from 100 to 120,000, and that 5 units had sold in 2010, and 14 were currently listed for sale.
What does the respondent state about the local real estate market within this?
That the market was weak. There are signs of weakness, and they should sell within 4 to 6 years. And also, he indicates on page 12, this is the next last paragraph, signs of weak recovery in the real estate, doubtful if significant recovery will occur in the real estate market for 2 to 3 years.
However, even though he makes that statement, how long does the respondent state it will take to sell all 73 condo pads?
4 to 6 years.
And where does he say this?
This is on the next to last paragraph, page 12.
Are those two statements consistent with one another?
No, sir, I don't.
Why not?
It just is it 2 to 3 years? Is it 4 to 6? What's happening? Give us more definition or more explanation of what's happening in the marketplace. Trends were not properly analyzed in the marketplace.
Did you find any support, data, or analysis within his report or his work file answering those questions?
No, sir, I did not.
What was the discount rate respondent used for the forecasted condominium sales in this 2010 report?
It's 12%.
Did you provide any basis for the 12% figure in the 2010 report any differently than he did in the 2009 report?
No, sir, he did not.
What did the respondent say about the discount rate, comparing it to that of a new startup development?
Indicated it should be lower since this was a first-of-the-kind development.
Did the respondent provide any data support or analysis supporting that contention?
No, sir, he did not.
Pages 12 through 13 of Exhibit 7. Does the respondent provide any different analysis or justification for the development of his discount rate, the state of the local market, and the anticipated increase in lot value than he did in the 2009 report?
No, sir, he did not.
What are your findings regarding whether the respondent complied with applicable use provisions on?
And due to lack of supporting information, I find it violations of use PAP.
Are those the same violations that you previously testified?
Yes, sir, they were.
All right, Mr. Orman. Looking on page 13 of Exhibit number 7, under the discounted cash flow analysis section of the respondent's report. Perform, sir, your own calculations of the actual mathematics which the respondent used in forecasting the lot prices over the 4-year period.
Yes, sir, I did.
And what figure did you come up with that the respondent actually used?
He indicated he's going to use a 5% increase per annum, but if you look at the lot prices, they've only increased 3% per year.
And what percentage did the respondent expressly state in his report he was utilizing?
5%.
Your mathematics resulted in a finding that respondent actually used what percentage?
3%.
Had the respondent actually used a 5% per annum increase, as he stated he was, what would this have done to his overall value conclusion?
It would have made a mathematical difference in it, and a mathematical higher difference in it.
Overall, what's your opinion on the respondent's utilization of the income approach and discounted cash flow analysis in both the 2009 and 2000?
Due to the lack of supporting information and errors in mathematics, and appraiser just has not completed recognized techniques, and I found violations, as stated earlier.
And would those be the same violations that you previously testified to in the income approach section?
Yes, sir, they are.
All right, let's go to page 10 of exhibit number 10. Page 10 of your review.
Yes, sir.
And on page 10 at the top, you address the respondent's reconciliation in both reports, correct?
Yes, sir, I do.
Let's start with the respondent's 2009 report, which is exhibit number. Reconciliation is found on page 19 of exhibit number 6, correct?
That is correct.
Do you have any concerns about the sufficiency of the respondent's reconciliation set out on page 19 of exhibit number 6?
Yes, sir, I do. It's there's insufficient information to understand the quality and quantity of data that has been presented and how it's been reconciled into the values. Also, assumptions and other things made on that page that were not fully explained or have not been fully explained.
What is your opinion regarding whether a respondent complied with applicable provisions of USPAP regarding the reconciliation that he provided within his 2006 report, which is exhibit number?
You talking about 2009 report?
I'm sorry, 2009 report, which is exhibit number 6.
Based on my findings, the report does not present sufficient information to enable intended users to understand and rely on the conclusions, which leads to use patent violations, dealing with scope of work, 1-6A, A and B, and Standard Rule 2-2, B8.
What essentially would the scope of work acceptability require in this scenario?
What would intended users expect, the intended users of this product expect, and what would the appraiser's peers expect for this type of product?
Do you consider yourself a peer of this respondent?
Yes, sir, I do.
Would you have expected more?
Yes, sir, I would.
Let's look at the respondent's 2010 report, exhibit number 7. In exhibit number 7, do you find any actual reconciliation at all, Mr. Orman?
No, sir, the only thing I found was an allocation of value on page 16 of that report.
What was a respondent doing by considering this section an allocation of value?
Actually, looks like that he was trying to do a partial interest appraisal and divide out the values of the interest, which if he was trying to do a partial interest appraisal, we open up a whole another set of requirements that weren't met.
And what page of exhibit number 7 do you see this allocation of value section, sir?
Page 16.
Does the respondent include on page 16 within his allocation of value a contribution to value for a proposed clubhouse site?
Yes, sir, he does. He indicates the proposed clubhouse would have a value of $159,000.
What, however, did the respondent state earlier in this report?
Found this inconsistent on page 12 of the report. It is quoted that the proposed clubhouse and recreation facilities proposed for the subject development will have a positive influence on value. But as of this date, the exact contribution of these amenities cannot be measured accurately and are not included in this appraisal.
So is your testimony that the respondent specifically stated previously in the report that he could not arrive at an amount of a specific contribution to value for the clubhouse?
Yes, sir, that is correct.
Did the respondent offer any explanation for these inconsistencies?
No, sir, there was none provided.
Did you find any anywhere else in his report or within the work file?
No, sir, I did not.
Did the respondent, Mr. Orman, on page 16 of exhibit 7, did he use the correct value indication for the 73 proposed condominium sites?
No, sir, he actually used the development cost.
And how are you able to come to that conclusion?
Based on the information presented in his report, he showed development cost to be $1,460,000, but when he had an indicated value earlier in the report, he indicated that value to be $1,500,000, and by discounted cash flows. And without the explanation, I'm not really sure what the respondent was trying to do.
And where do you arrive at the conclusion that the respondent came up with a $1,460,000 value for the 73 condo payments?
That is going to be on page 11 of the report, about midway down.
Respondent offer any explanation for why he used in this allocation of value the $1,460,000 development cost as opposed to his discounted cash flow analysis cost?
No, sir.
Did you find any data, support, or explanation within his report or his work file on that point?
No, sir, I did not.
Within this 2010 report, which is exhibit number 7, did the respondent offer any final reconciliation?
Not to my knowledge. I found none.
As to the respondent's reconciliation within the 2010 report, what is your opinion regarding whether he complied with applicable provisions of use patent?
Information I have doesn't appear to be a reconciliation, does not offer adequate reasoning or conclusions. does not present sufficient information to enable the intended user to understand how these conclusions were arrived and how an intended user could rely on these conclusions. Therefore, I found that there were some USPAP violations, which would be Scope of Work Rule 1-6AB, 2-2BA, all in the 210-11 USPAP.
Finally, Mr. Orman, we come to your comments on the respondent's certifications.
Yes, sir.
On page 10 of your review, which is exhibit number 10.
Yes, sir.
On page 17 of the respondent's 2010 appraisal report, at the last few lines before the very end, on page 17 of exhibit 7, what does the respondent state the date of market value to be?
September 18th, 2009.
What do you consider that to be?
An error. Earlier in the report, it was indicated that the effective date of this appraisal report was September 15th, 2010.
Do you find any mention at all in this 2010 certification on page 17 of Exhibit 7 that the respondent also previously appraised this subject property in 2009 and in 2008?
No, sir, that was not in the report.
And what is your opinion regarding the respondent's certification for failing to include the fact that he had previously appraised the
A violation of USPAP's ethics rule? We're required to notify intended users at the time that we receive an assignment or when we first know that we have had previous experience within the last 3 years.
And when was that provision of USPAP's ethics rule in effect?
2010.
Was that provision in effect in 2008 and 2009?
No, sir.
Thank you, Mr. Orman.
Right. Commission members, this is your opportunity to ask questions of the expert witness.
Anybody want to question the witness at this time? Commissioner Stanford, you're recognized.
The deed for the subject property was not included in the reports based on what we have here, but the deed was provided in his work file. Is that safe to say?
There are deeds in the work file, yes, sir.
Was there any feedback with regard to, and it may be here and I've overlooked it, but with regard to the discrepancy in the size, was there any?
There was, I just felt like that, in my review, there was a little feedback, and I felt like that was probably something to do, because I understand in a development project, you may lose some frontage, you may lose some part of that problem as what city or counties may require. I didn't really harp on the size differences. I just wanted to state the facts, that there was some size indication differences, and that should have been discussed. As appraisers, if we go out and look at a property that that we think is a certain size, and we find out something different, it would behoove us to explain to our readers who may look at a county record and try to figure out what those differences are. That's just kind of taking the extra step a little bit to ensure that your readers understand what you're trying to do.
Person here that the complaint is against, is he given the review, or is that just that what he would have got Mr. Orman's review as of today, or how does that work?
If you may respond.
Thank you. The way these matters occur, Mr. Standifer and members of the commission, is that these are put on the legal report. the summary of if in fact the vote of the commission is to offer the respondent correspondence that is sent by Ms. Baird directly that says, we obtained. This respondent was provided a copy of the review a long time ago. Office. So the only written response you have would be the document. Was not actually given a formal copy of Mr. Orman's review because we don't discuss.
Summary, fair to say? Okay. I don't have anything else at this time, Mr.
I've got several questions or comments, and I don't know if this is at the right time or not, but I had a couple of questions in reference to things that might be in the work file, might not be in the work file, and just things in general that help me get a better handle on what all's going on. I appreciate you talking about that size and the CRS differences and those things, and I appreciate Commissioner Stanford's question about the deed, because many times I was looking for a plat in there or something that would give me that legal, and I did not, and so I know that, and I understand you said that was not a major deal. You're just pointing that out, but I was wondering about the deeds and the CRS, because many times CRS data is not accurate, but you indicated you were pointing that out more to let us know rather than relying on
And some
that.
kind
But-
of communication with, with the potential readers of the report.
Yeah, well, and I'm wondering if it was in the work file or not.
Did not find it in the work file.
But I guess that's not unusual that you see some variances there sometimes. But when I'm looking, and I was trying to go back and through all the different reports, I'm just looking at notes I made here. On page 10, well, it might have been different in each report, but where they had the 15 land sales, they had the sale of the subject that was written up, and then it had sales of other multifamily properties in the entire region where they did some statistical analysis on. Those were all it says they were all multifamily properties
Right.
in that area. And I've seen that kind of analysis before, and it certainly did bracket it. Was any of those sales, was the data sheets in the work file?
There were some detailed sheets. Now, one of the questions that Mr. Joseph asked me, and I failed to respond to the whole question, what got me about those sales, we can do statistical analysis. We can take numbers and lots and put out there. But the questions I had about those sales, the report did not identify the sales, how similar they were to the subject. Were they really similar to the subject? The other question I had, are they in subject's market area? That was not discussed. There was no distinction analysis indicating the varying level of multifamily. In other words, what kind of density levels can these properties, obtain, and how does that affect their values? The more numbers, more rentable properties you can get on those multifamilies, or the more numbers, you got some value there. So proposed density levels, number of units that could be placed on those sales. How does this compare to the subject? None of this analysis was provided. Were these multifamily sales purchased for projects such as subject or apartment complexes? None of that was discussed. And that's the reason whenever we've got these sales, how do
Hold
we
on.
discuss that information?
What was in the detail sheets of each one in the report? Not the report. the work file.
In the exhibits, I think it was just the sales information.
I'm sorry, you just told me there were detail sheets in the work file.
Well, that's what he called them, what they called them. Basically, and if you'll look at Exhibit 5, you can look at those, and it's got the multifamily land sales, it's got information, but there's no no just analysis addressing these different types of projects and how they compare to subject project.
So like I said, I have not had a chance to go through all of this, but you're telling me this CRS printout and these MLS documents that go along with each CRS, that's the background data on each one of these sales,
Yeah, we got
right?
background data, but the analysis of how they
And
compare.
and you can tell here, you know, what was done with them. I guess what I'm saying is in a summary appraisal report, you're not gonna get all that in the actual report itself. So, you know, it says that it is properties that were purchased for multifamily development in that general vicinity. I know in Jackson, we don't have that many multifamily developments, and so we would look at the entire aggregate just to see what's going on. So, I mean, it says, and I'm not beating up on it, I'm just trying to get all this out so I can make an informed decision. But it says there were for multifamily development in the Johnson City and Kingsport areas, and that he summarized it, and then, and it was in the work file, and then here's the stuff in the work file, so.
Well,
Anyway.
the question I had with the work file is it's fine to summarize the work file. In the work file, that analysis hadn't taken place. I didn't know how these sales compared to the subject property and the different nuances of these properties as the subject property.
Okay, all right. But in looking at that, there is some, it's not as if there was no data, and I just picked a number out of the air.
Okay.
There is some data there. I mean, I've seen a lot of reports where there's no data.
Oh, well,
They
yeah.
just said it's X. At least here I got 15 sales that say it's something. And I'm just trying to rationalize in my head where we're going. The one thing that I found, was there any, he had mentioned on page 14 of Exhibit 6, that the developer had started construction on 15 condominiums. So I'm concluding he'd already broken ground or done something there. And then reportedly had sold 2 of them, and reportedly is nothing more than me saying I reportedly saw that. So, I mean, there's not any concrete information there, but he says there's pending contracts on 2 to 4 additional sales. Were those pending contracts in the work file?
No, sir, I didn't see
Was there any
of-
physical notes written?
There was nothing that would support, you would think that information would be important enough to at least analyze in the report.
I mean, reportedly, you know, I understand how that word's flopped around, and if something is out of the ground and you can physically see it, I understand that. The question there is on the 2 to 4 condo units that had pending contracts. I didn't know if he'd made a note, something, the developer orally told me these were under contract, or there was actual a contract.
Find any supporting information.
Okay. Okay, at Exhibit 6, on the building up the cap rate, the discount rate, excuse me.
Yes, sir.
You know, I don't have a problem with building up a rate. You're using a safe rate, a management factor, illiquidity. He has a risk factor in there that would account for, you know, some of those issues that you had mentioned. And so I don't really have a problem with that. I didn't know if there was any kind of realty rates or any other thing that would support some of that data. Was that in there?
I did not find anything that would support a built-up, a built-up rate.
And I see there's nothing wrong with doing a build-up rate. I have no problem with that. I did compare all 3 from 09, 08, 09, and 10, and there was no change in any of that. I do find that's kind of,
Well, that was
that's
another.
perplexing a little bit.
There was a lot of information in the 09 report and 10 report that you would think with the changes in market conditions would be addressed that were still the same.
It does mention that the Kingsley project across the street selling out and I can't remember what my question was on that. Maybe I'll come back. The one thing I'd say I can't remember, and you're an USPAP instructor, so I know you're gonna know this. As far as giving notice that you've done the appraisal before, within a 3-year period, what version of USPAP did that become,
I believe it was 2010 was the first year.
okay, 2010?
Yes, sir.
Okay. And the reason I was asking it, because I couldn't remember, I knew that at some point they had said that. And as I'm looking for that, in 2008, it was for First Community Bank, Steve Sweeney. 2010, there again, it was for First Community Bank again. So there would have been some internal knowledge that they were redoing that loan. And then again, in 2009, it was for Jerry Green. And in 2010, it was for the same individual, Jerry Green. And so if it went into effect in 2010, he wouldn't have called him back if he had, that conversation might have occurred, but it wasn't in the report. It should have been in the
Should
report
have
in
been in the
210.
certification of the report.
Yeah, I agree, but I agree with that. But also, talking about the intended user and use, an anonymous submitter of a report is not may or may not be the intended user. Could have been someone from First Citizens Bank that snuck it in. Could have been a clerical person. So if that's the case, then but the intent. My point is the intended user and the submitter for the complaint. He wouldn't understand it anyway. It wasn't written for him. It wasn't for his intended use. He wasn't the client. So in my mind, if the intended user is the one submitting the property and the other appraisal saying there's a problem here, then that tends to be a lot greater weight and burden on the appraiser than somebody off the street that's sending it in under the cloak of darkness. Because they're not going to be able to understand it anyway. I mean, it could have been a restricted use report for that matter, and they wouldn't even have had any data. And an anonymous person could send it in. So anyway, so from an ethics standpoint, it should have been in the 210, the handwritten part, but from an intended user not knowing, they shouldn't have known. I mean, they weren't the intended user of the client. And then the last thing, but there were inconsistencies. I agree with you. I did notice inconsistencies throughout. And one thing that jumped out, I don't understand this, was there was a certification for an unlicensed trainee in one of the reports, but it wasn't in the other two reports. So what was Mr. Schultz's contribution of this work product?
That was a question I was hoping somebody would help me answer. This is just part of that. It's in the Exhibit 6, I believe. It's in that report, 2009. And
I just didn't, and he didn't sign it. That was
he didn't
even,
sign it, and
there's no value on it.
I had no value, no information. I didn't know if this, if I may speak a little freely here, these reports appear to have been cloned and cloned and cloned, and I'm not sure if that page was supposed to be there or not. But with that said, let me go to, if you'll look on page 20, see, I don't understand the numbering of this report either. It's the third page in of exhibit number 6. He's on there too. Actually, we could have a violation of work file, ethics rule work file, record keeping, because you don't have a true document, a signed document in file. I did not cite that violation. That would be up for the commission to add or the.
Well, I didn't understand the page numbering because on Exhibit 6, it starts, my first page is
Starts with 24.
24, and then midway through, it goes back to 1 and starts over again.
I'm not going to make,
And then, and then it, did you want to say something, Commissioner? So, yeah, that's, the only other question that I had was there was in the certification, the respondent was indicating he had given significant professional assistance. And so I didn't understand how you could give significant professional assistance if you were the respondent who signed it.
Again, I saw that and was just kind
So,
of.
I mean, I take all that to say I think I may agree that this report was prepared in '08 and cloned numerous times, and maybe some of those things just slipped in. But there's things there I see that don't make a lot of sense. There's some things I see there that I think may be nitpicky. And anytime there's not, you can always fall back on whether there wasn't enough evidence or wasn't enough evidence. So you could say that about any report anybody's ever written. But anyway, that's all I had. Any other questions? No further questions?
I've got one question.
Commissioner Stanford.
Exhibit 5, this is under the work file. This is everything that was submitted as part of the work file. Is that correct? Thank you.
Can I dovetail on that? Which work file was this Exhibit 5? 08, 09, or 10? Or all of them?
Yes.
All of them?
Yes, Mr. Joseph, you may respond. If you
My
know.
understanding, Mr. Chairman and members, is that he submitted the work file information after the 08, this follows the 08 report. If you look at some of the print dates on some of the computer material at the very end, I see.
Yes, sir.
But if you look at the conclusion of every other report, 6 and 7, you will see some information at the back which could technically be part of the work file. That is, he uses some type of accounting paper
Right.
and makes handwritten notations to the 2009 report and
Right.
the 2010. That's the only additional work file information that came in on 09 and on 10, and the after the 2008 report.
So let me see if I understand you, Counselor. On Exhibit 6 and 7, the handwritten document at the back, those might have been a part of that work file.
We simply compiled it the way he sent it in to us on his disk.
So there wasn't like an 08 report and an entire 08 work file, an 09 report and an 09 work file, engagement letters from the lender or anything of that
There
sort?
may have been something, if you look at the conclusion of exhibit number 6, there may have been an email engaging him for the 09 report, dated August of 09, at the very end of exhibit 6.
I'm just wondering if this is an incomplete work file on the exhibit for the 09 and 10 reports. If it is, if it's not, then that's scary. But if it is
All
not,
he
but,
submitted, and pursuant to exhibit number 1, he was asked to submit a complete.
other questions, Your Honor?
All right. And you have no further witnesses, is that correct?
Your Honor, we have no further witnesses and
All
no
right.
further proof.
Would you like to make a closing argument?
Your Honor, I do believe that the commission has been inundated sufficiently facts. I would well, I can make a brief closing, and at the same time, I'd like to submit proposed findings of fact
Okay, I
and
was wondering
conclusions
if you
of
had
law.
proposed findings.
Sure.
Why don't you go ahead and publish those to the commission? And the witness may return to his seat in the audience, correct?
Yes, Your Honor.
Right.
Briefly, members of the commission, I have submitted for your consideration of law for this matter, which the state believes have been given the testimony of which have not been rebutted behavior such that they should be considered extraordinarily severe. Bear upon fraudulent, intentionally misleading conduct. That the respondent be assessed a $1,000 civil penalty. To do so, the respondent's credential be indefinitely suspended.
Thank you for your closing argument. Would you like me to go ahead and charge the commission now, or did the commission want a lunch break, or what's the pleasure, Mr. Chairman?
Personally, I would like for you to charge us and move forward.
Okay,
Is
all
there
right.
Is
I'll
that a
do
consensus? Yes.
Okay. The commission has now heard the proof in the case of David W. Harris, docket number 12.36-120897A. The respondent, David Harris, is before you for alleged violations of the state licensing and certified real estate appraisers law, TCA 62-39-101 et sec. In particular, TCA 62-39-3265 concerning violating any of the standards for appraisals and appraisal practice, and 62-39-329 concerning the intent that real estate appraisals be performed in accordance with generally accepted appraisal standards. TCA 56-1-311A and Rule 0780-05.11-.011 allow this commission to assess investigatory and hearing costs should you see fit. As sole and exclusive finder of the facts in this matter, you must conduct open deliberations and make findings of fact and reach conclusions of law based on the facts found. Your findings of fact must be based solely upon the evidence presented to you in this hearing. This evidence includes the testimony of witnesses and any exhibits introduced. The notice of hearing and proposed order filed by the state are not evidence, but may be used as a guide to assist you in making your findings. But it's the sole responsibility of the commission to make its own findings in this matter. The state's attorney has argued his respective theory of the matter. The statements of counsel are not evidence, but are merely arguments to persuade you to see the evidence in the light most favorable to their position. Give such statements whatever, if any, consideration you feel is appropriate. In making your findings, the commission must make the determination as to the credibility and weight to be given to the evidence presented by each witness. If there's conflict in the testimony between witnesses, it's the responsibility of the commission to reconcile those conflicts if possible. But if it is impossible to reconcile the conflicts between witnesses, the commission must determine which witness's testimony to give the most credibility. In reaching such a determination, the commission should bear in mind the following principles of law. The law presumes that all witnesses who are sworn to the oath testify to the truth. It is the obligation of the triers of fact to attempt to reconcile any discrepancies in the testimony between witnesses, but if this is impossible, it is necessary for the triers of fact to determine which witness speaks the truth and which witness has stated a falsehood despite his or her oath. In determining which witness is believable, the commission has wide discretion. However, the commission should consider in determining the truth the witness's interest, if any, in the outcome of the matter, their good intentions, their seeming honesty, their respective opportunities for personal knowledge of the facts about which they are testifying, and their conduct and demeanor on the witness stand. If the commission finds it helpful, it may weigh the evidence mentally on the scales of justice. If the scales tip in favor of the state, the commission must find for the state. If the scales tip in favor of the respondent, the commission must find for the respondent. If the scales are evenly balanced, the commission should bear in mind that the state has the burden to prove that the discipline sought, the civil penalties sought, are warranted. After a full and impartial view of the evidence presented to you, the commission may find, for example, that no violation has occurred, or that a violation has occurred but no penalty should be imposed. It may find that a violation occurred but that the state's proposed civil penalty is either too high or too low. That a violation occurred and that discipline is warranted but that no civil penalty should be imposed. That a violation occurred and that restrictions or conditions should be placed on the respondent, or that a violation occurred and the penalty the state seeks is proper. The appropriateness of the penalty may include consideration of a number of factors, for example, whether the amount imposed will be a substantial economic deterrent to the violator, the circumstances leading to the violation, the severity of the violation and the risk of harm to the public, the economic benefits gained by the violator as a result of noncompliance, and the interests of the public generally. In assessing violations or a violation, the commission may consider the evidence that the parties have introduced, including but not limited to whether the conduct was or is of a continuing nature versus was a one-time occurrence. Additionally, the commission may also consider what it has done in previous similar matters for comparison purposes. You must also indicate a policy reason for your decision. It's improper for the administrative judge to participate in the commission's debate and deliberations because it's the commission's sole responsibility and duty to determine the findings of fact, conclusions of law, and policy reason for your decision in this matter. I will, however, be available to answer any legal questions on the record that may arise. Chairperson Johnstone, please proceed with the deliberative process.
Thank you, Judge. May I ask you a question in terms of procedure? We'll have the findings of fact, the conclusions of law, and then there'll be a proposed judgment.
Right.
And the policy decision, where does that lie in that process? Is it?
Policy decision is usually last.
It's after the judgment?
Right.
Okay. Okay, now, do all of the findings of fact need to be read into the record, or can we reference some of those?
You could make a reference to a particular document,
Okay.
so you wouldn't necessarily have to read each one word by word.
Now, if you want to modify that, and say,
Certainly, if they want to modify
if they
it,
modify
then
it,
have to
okay. All
look
right.
at the individual word.
Okay. Does the commission understand our responsibility and what we're getting ready to embark on? The state has provided us with the proposed findings of fact and conclusions of law. And in each section, there will be a proposed finding of fact, a proposed conclusion of law, and a proposed judgment. And so we, as a body, will need to determine what we feel the actual finding of facts are and vote on that, conclusions of law, and vote on that, and our judgment, and vote on that. What's before us is the proposed findings. We have to determine where in that lies what we're going to judge as to be those findings, and at the conclusion of that, our policy decision as to why we did that. So, under the findings of fact, those are outlined on page 1, 2, 3, 4, 5, 6, 7, 8, 9, and 10 of the state's proposed findings of fact and conclusions of law. Do we have any questions on any of those particular findings of facts that we agree or disagree on? Now's the time for some deliberation upon those findings of fact. They're also broken down into subsections. Subsection 1, Roman numeral 1, is on site description and improvements. Subsection 2, sales comparison approach. Subsection 3 is the income approach. Subsection 4 is reconciliation, and 5 is certification. Now, if you agree with all of these, that means you agree with 100% of the state's proof on the findings of fact. And personally, there's a few things that I thought, that's kind of nitpicky, I'm not sure about. But to be able to go in, but there was quite a few things there too, so to be able to go in there and isolate each one of those might be a difficult process. But we'll start. Won't put anybody on the spot, but we need to probably move forward through this.
My commentary on it is this. I find that in general, I agree with you. There's a few nitpicky things in there, but the state's burden of proof, I think they submitted enough evidence for the majority of these things. Now, how high a violation do they rise to? I think that's to determine after we approve or disapprove the finding of fact. But I think a lot of it, the violations identified, I think the state has made its case.
I think that is correct. In terms of the judgment and conclusion and policy decisions, those will be handled separately. What we're trying to determine now is the findings of fact. Did the state, were they successful in that burden of proof on those findings of fact? Benford, you're recognized, sir.
On the finding of facts for the certification, it's my understanding that prior to year 2010, you were not required to disclose if you had appraised a property previously or worked on it in some manner. Is that accurate?
That was my understanding from my questioning earlier to the witness.
Just as a
Hold on, just to kind of maintain order, I don't think we can allow, unless the judge gives us permission, to re-question witnesses. But in reference to your question, I specifically asked the witness, at what year was that responsibility or that requirement put in to where it had to physically be put into the report? And he indicated 2010.
I'd like to clarify within the finding of fact under Roman numeral number 5, disclosure of previous appraisals, disclose his previous appraisals of the subject property in 08, 09, and 2010. It would appear that it would only be appropriate to have 2010 there as a conclusion of fact.
So you're making it, would that be a motion to amend the certification section under 5 on page 10 to remove the years 08 and 09?
Well, I'm not sure about the correct procedure. I think it's somewhat unclear there with regard to, are you making that charge for 08, 09, and 010? And by getting it on the record, I think, in my judgment, it's been clarified as to where the commission stands.
I guess my concern is if we vote on this in lump sum on all of the findings of fact, unless that particular line, which is the next to last line on page 10, is stricken or amended, then there's going to be no way to document what transpired.
I think if you read the whole number 19 under Roman numeral 5, it says it references the 2010 report specifically, and in the certification for that report, it says that he fails to mention in the 2010 certification that he previously appraised the property in both 2008 and 2009, which would fall within the 3-year period he would have been required to report. I think it states it fairly clearly that it's referring to the 2010 report only.
You know, I agree with you as I read this, because it says in 2010, first line, and it references 2010-11 USPAP on the last line.
Right.
And it doesn't say that he did it in 08 and 09. It says he didn't reference those in the 2010 report. I agree.
That would
I
be
agree.
acceptable to me.
I think that is, me too. Is that acceptable to you to leave it as is? 'Cause I think it's accurate.
It is accurate. It's somewhat confusing, but yes, after the dialogue, I'm fine with it.
Any other discussion in relation to findings of fact? If not, I would entertain a motion to accept the proposed findings of fact as outlined on pages 1 through 10 in the state's proposed findings of fact and conclusions of law.
I make that motion.
It's been moved by Commissioner Walton.
I'll second it.
And seconded by Commissioner Barilla. Is there any discussion on the motion? Not? All in favor, signify by saying aye.
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 Any opposed? Proposed findings of fact have been approved. Next item is the conclusions of law. The state's proposed conclusions of law are outlined on page 11, 12, 13, 14, and a portion of page 15. These proposed conclusions of law reference Tennessee Code annotated 62-39-326, parentheses 5. They also represent and reference, 60 Tennessee Code annotated 62-39-329 and Tennessee Comp R and Reg 1255-5-.01, parentheses 2. Then they further continue in referencing the various USPAP standard rules numbers and the conduct section as well. Any discussion on these conclusions of law? Whether the state's burden of proof or these findings of fact correlate with the referenced state law and referenced uniform standards? Everyone had an opportunity to review those? Deliberation, I would entertain a motion to accept the proposed conclusions of law referenced on page 11, 12, 13, 14, and a portion of page 15 as detailed in the state's proposed findings of fact and conclusions of law.
So moved.
We have a motion from Commissioner Walton. Do we have a second?
Second.
Second from Commissioner Johnson. Is there any further discussion on these proposed conclusions of law? If not, all in favor signify by saying aye.
Aye.
Any opposed? The conclusions of law have been approved. Under the proposed judgment section, and that is on a portion of page 15 and page 16. And I'll give you a moment to look over those. And actually, these are fairly short. I'm going to read these into the record, if that's acceptable. The proposed judgment, item 1, is the respondent is assessed a $2,000 civil penalty based on violations of USPAP and Tennessee law set forth above. And that's $1,000 as to the violations committed in each of the 2009 and 10 appraisal reports. The Commission notes that the respondent has committed numerous violations, more than 10 in these reports, and recognizes that a higher civil penalty could be assessed, but after consideration of the facts set forth in Tennessee Code Annotated 56-1-308, parentheses B, and Tennessee Comp Reg R and Regs 1255-5-02, parentheses 4, determines that a $2,000 civil penalty is a sufficient sanction. Item 2, the respondent is required to complete whatever corrective actions, educational courses, to assist him in the areas he has committed violations as deemed appropriate by the Commission. And 3, respondent is assessed all investigatory and hearing costs incurred in this matter pursuant to Tennessee Code Annotated, the previously referenced Tennessee Code Annotated 56-1-311, parentheses A, and Tennessee Comp R and Reg 0780-5-11-.01, assessment of investigatory and hearing cost. Item 4, the respondent is required to deliver execution of his completion of the required corrective education, if assessed, I'm adding that, to the Office of Executive Director, and shall pay in full the $2,000 civil penalty, if assessed, I'm adding that, and all investigatory and hearing cost, if approved, detailed in the Commission's final order within 90 days after the filing date of such final order. Such respondent failed to comply with these requirements by the stated deadline, his certified general real estate appraiser certificate shall be immediately suspended and remain suspended indefinitely until he fully complies with this order. So those are the 4 proposed judgments. We can take each one of those individually, I think, to just work our way through it. Item one, the $2,000 civil penalty, one for each report. Is there any discussion on that?
Yeah, honestly, in my opinion, I feel like the civil penalty is somewhat punitive. I think it had been mentioned earlier. I think there's lots of negligence here, but I don't see any intent or willful conduct that I really want to be punitive toward. And I believe that having these charges, I'm sure, has got his attention. I'd much rather move toward education. And of course, I think the state should be reimbursed for all their costs involved. And I think, something like this is on your record, you're going to be paying for it for a very long time in terms of E&O and a lot of other things. So, in my opinion, I'd like to do away with the civil penalty.
I want to, looking back, I'm trying to think from a policy decision in the past, and we'll have some of these this afternoon, where we have standard rules violations come to this body, and we assess penalties every meeting in the form of, some dollar amount that we come to a conclusion on based on the violation of standard rule 1-2A, blah, 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 and so forth. And there was certainly some standard rule violations there. So I don't know that applying some type of civil penalty is being inconsistent with past actions of the board. That's just my thoughts. I do think that, I don't know that that's an excessive amount for the number of penalties, but I mean, I'm open either way on that. But I don't think that it would be in violation of what we've done in the past. I agree in terms of corrective education. I think that the one thing that I would like to see, I mean, I don't know if there's a class out there that exists, but work file documentation is one that would be good if that exists. I've never seen a class on work file documentation, but that's something I think that's important. As a point of clarification, a point of information, I would like to ask the state, do we have an aggregate amount of investigatory cost in hearing compiled for some type, for a reference point right now?
Well, what we would do, Mr. Chairman, is I would ask for office, the Administrative Procedures Division, to compile a cost bill I will compile all that and have line items within the final order, which would give a full amount.
Thank you. Now, would the state, can I address the council, Your Honor? Can I address Mr. Joseph, Councilor Joseph?
Sure.
Okay. Councilor, would your time and your cost that comes out of your office also be on the top of this? Or is it strictly court reporter, the administrative judge, and the reviewing appraiser?
That question is still, I don't want to say up in the air, but there's some question as to whether we have that authority. The statute gives us the authority to have the time of prosecuting attorney. Custom and practice has been that we never have done it in the past. So I would not be doing it in this case until we were to amend some rule.
Thank you, Mr. Joseph. As I'm looking at that, if I'm just doing a preliminary, we've got a $1,200 review fee, which I heard the witness testify to, and I heard the witness testify to a $200 hourly rate, and it's going to be minimum $1,600. It's an 8-hour day, and I don't know if he's getting drive time or whatever, but you can say there's $2,800 there, and an administrative judge fee, you know, I can easily see probably $4,000 here, plus the overnight expenditures. So, you know, that's, in my mind, that might negate some of these civil penalties that Commissioner Walton has already referenced. And he is right. Going forward, there will be a lot of explanation to do in terms of E&O. Every time this respondent goes to get E&O insurance in the future, he's going to have to provide all of this documentation. And 4 and 5 years down the road, it continues. It doesn't stop. So that's punitive enough
All right,
in my
the
mind.
cost of E&O, if you've ever
So that, I mean,
had a case,
but
increases your E&O, so.
so that's quite punitive. By the same token, I don't know that he understands. You know, it's beyond belief that you wouldn't show up for one of these hearings. I just have no. I mean, I know he was served, but something. There's no I can't understand that at all. So, the civil penalty. Any other discussion on whether that's punitive, or are we making, or is the administrative and investigatory cost enough? And I agree with Commissioner Walton. I think those should be included.
Stone, it's my opinion that the administrative cost and the investigator's cost would be sufficient without.
What about the corrective education? I mean, I'm thinking out loud here. Everybody's going to be it's got to take USPAP. So requiring somebody to take USPAP is a waste of a corrective educational opportunity, because it's going to be taken anyway. I want to hear the board's thoughts on that, or whether it's going to be of any benefit. And is there anything out there that would be of benefit?
I'm thinking along the line of narrative report writing class, and like you said earlier, if there's some sort of record-keeping class, those two things just seem like to be the major violations and downfall in these reports.
Agreement that he has to take USPAP every 2 years, so that's really not. Report writing was probably our best course of action.
Well, can I speak? I want to speak to that. I was looking through the resume of the respondent, and noticed that they had not. I know, in the organization that he's a designated member of, there's a continuing education requirement that some members have to stay current on, and it all depends upon when you were conveyed your designation. And his designation was conveyed back in the 70s, of which that requirement was grandfathered. My designation was conveyed in the 90s, and mine is not grandfathered. And some of those continuing to educate, or the qualifying ed or education for that designation, such as the narrative appraisal report writing, has evolved over that time, and I would think it would certainly be much more extensive than it was in the 70s. Now, in terms of, I will say I've had that course, and in terms of writing an appraisal report that's in compliance with the newest USPAP that just come out, it may be way overkill. But by the same token, it might be enough to get those reports a little bit more up to snuff. So I would be okay with some type of report writing. That would be acceptable to me. Would other members of the board?
I would agree with you, yeah.
And I would think I don't know what other appraisal organizations have for report writing. And there may be some other coursework out there, but I know the Appraisal Institute's narrative and appraisal report writing is very good. The only downfall of that is it may be offered in some obscure location and you have to travel and spend a lot of money to get there and take it. That's the only thing that I would, no, I don't think you can do it online. But, I think it is offered in the major metropolitan areas. Yes, sir, Commissioner Stanford.
So the report writing course, that you're thinking that you can't take that online, you have to
I
attend that
don't think so.
physically?
It's a full week course, the one I'm thinking about. Now, there may be a 2 or 3 day course. I'm not aware of that. Can I ask Your Honor, can I ask Ms. Avery, yes, about education that might cover that?
Sure.
Ms. Avers, are you aware of any less than 1 full week courses that would cover report writing?
I believe there's a 30-hour general report writing course, but I don't know whether it's online or
It's 30 hours, so it'd be
30-hour, I believe it's a 30-hour course,
that's the one I'm thinking about, I think.
but I don't know whether it's online or in class. To know.
Dr. Barilla, have you seen anything in your tenure?
I wouldn't remember that, no. I mean, it is.
Do you think that if we, as a body, come up with an educational course of narrative report writing, we don't state whether it has to be online, or we leave it a little bit open in the event there's something there that can accommodate that? Okay.
I think we have to.
It says 90 days in the order, but maybe within 90 days to have, I mean, because like you said, it may not be offered until 120 days. But within that 90 days, he certainly would have to identify where he's going to go and make preparations for that, or online. Okay. So I think we've covered items 1 and 2 and 3. Item 4. Is the 90-day time frame to complete all these appropriate, except for maybe given some latitude there in terms of being able to identify the corrective educational opportunity within 90 days? May not have to have it finished within 90 days, but identified and signed up for. Okay. At this,
Let me ask you this.
Yes,
Would it be appropriate to stick with the order as it's written, but allow him to apply for an extension for the education portion with waivers if he cannot, if there's good reason where he can't meet that portion of it?
For an additional 90 days.
Mm-hmm.
well, so you're saying, we could, but if there's a consensus that the $2,000 civil penalty is going over what's gonna, is in some people, if we're gonna do away with that, then that's gonna have to be stricken from this proposed judgment.
You're right.
So we're gonna have to,
Amend it.
we're gonna have to amend it. So my thoughts is that we would just, it might be easier to make a motion on the judgment and just read it into the record, or amend that particular item. It may be easier to, from Commissioner Walton's standpoint, there were violations in there, so we can't say they weren't.
Right.
But there's, perhaps the respondent, you just zero those penalties out.
Would we say like a letter of warning or something like that?
Yeah, and substitute it with a letter of warning.
Down to a letter of warning, then you're saying there's no violation.
Oh, no, yeah,
on.
that's, well,
Hold on just
No.
a minute, I'm sorry.
I think you're up. Yeah, are we back on the record? Okay. Yeah, I think a letter of caution and a letter of warning are non-disciplinary, and so I think we'd have to do something. we could reduce it down to, $100 or something nominal, so that there is an acknowledgement of that. So, if we're looking at the proposed judgment, let's just, but it may be easier just to take them one by one and just, and rather than try, because I don't think there's any way to keep this intact. The more I've looked at it, I think there's gonna be a little bit of, things. So let's just take item one. Can someone make a motion and revise that to what they feel would be appropriate? And it can be pretty much verbatim, but you can change the monetary amounts if you feel that's appropriate, and then we can see if there's a second, and then we can debate it and vote it up or down.
All right, I'll make the motion that the respondent is assessed a $200 civil penalty based on the violations of USPAP and Tennessee law set forth above, $100 as to violations committed on each of the 2009 and 2010 appraisal reports. The commission notes that the respondent has committed numerous violations, more than 10, in the reports, and recognizes that a higher civil penalty would be assessed, but after consideration of the factors set out in Tennessee Code annotated 56-1-308B and the Tennessee Comp Rules and Regs 1255-5-.02 parentheses 4 determines that a $200 civil penalty is a sufficient sanction. That's my motion.
Second that.
A motion from Commissioner Walton, seconded by Commissioner Staniford. I have one question. When under comp rules and regs, 1255-5-02, parentheses 4, does it say, is that range in there allow for $200 to be a sufficient civil penalty?
The range is 50 to 1,000,
Okay.
50 to 1,000.
So we're covered there. Good.
Right.
All right, any further discussion? If not, all in favor signify by, now this is for the judgment portion. This is item 1 under the judgment portion. Is there any, all in favor signify by saying aye?
Aye.
Any opposed? Okay, item 2 under the judgment portion, respondent is required to complete whatever corrective educational courses to assist him in the areas which he has committed violations, as is deemed appropriate by the commission. Do we have a recommendation, a motion?
Make the motion that the respondent be required to complete a 30-hour narrative report writing course to assist him in the areas which he has committed violations, as is deemed appropriate by the commission.
We have a motion to take a 30-hour narrative report writing course,
Second.
seconded by Commissioner Barilla. Any discussion? Commissioner Staniford.
The Appraisal Institute is 30 hours, is that correct? We don't know what other organizations, we don't know what their report writing options are. I would be somewhat more lenient as with regard to the number of hours.
I'm concerned about is that I know I've taken some report writing classes that were only 15, and they're really geared toward residential. And that's where I wanted to make a distinction. I don't really care about the hours, to be honest.
You said narrative, but, well, that could be a residential. Maybe a narrative commercial report writing,
Something narrative,
co-
commercial, or general.
educational opportunity, and leave the hours off, because, and in that way, they've got to make sure that it has the commercial component.
Right. Like I said, the reason I said 30 hours because, like I said, we knew about the Appraisal Institute course. We know it's a good course and would probably meet what we're talking about. Whereas if we open that door I don't want it to get backdoored to him skate by with a little residential
Would you,
that won't benefit him.
would an ability to amend that motion that specify, to insert the language, a narrative commercial appraisal report writing course? That way you're not gonna be skating around the residential.
Right. How is I'm afraid that if we get restrictive on that language, that we may limit it to where, how's the Appraisal Institute course?
I think that was the point of the discussion, is that we know that the Institute's course is 30 hours. We don't know what the IFA course is. It could be 28 and a half hours.
But does
So-
it specifically say commercial in the Institute course?
It doesn't, not in the title, but in the curriculum it does. So, can we ask Ms. Avers a question, Your Honor?
Yes.
Ms. Avers, can you?
Requirement to get the certified general credential is a of the courses. I'm not aware of any course that says narrative report writing.
There,
It doesn't exist, he won't be able to take it.
Right, and the course and that course is a 30-hour, or could we say over 25 hours?
I would rather see the hour component be taken out of it and let the curriculum of the coursework be looked at by Director Avers to make sure it had a commercial component. And if it didn't, at that point, toss it back. And that way she could identify to see if it met what the gist of what we're trying to do here.
I would agree with that.
Call the motion and restate the motion. a new motion.
I'll withdraw my motion.
Okay, the motion's been withdrawn. Is there? Jennifer, would you like to make a new motion?
I would make a motion that a narrative commercial report writing course be attended, and approve such a course after such course is submitted by this individual.
Heard the recommendation for a narrative appraisal writing course with the content of the coursework to being reviewed by Ms. Avers prior to applying. Is there a second? And this is for discussion. We can certainly vote it down and amend it.
Second, so we're open for discussion.
We got a second from
All right.
Mr. Walter for discussion.
I think the way that we need to frame it and the way we need to phrase it would be a general report writing class with a commercial narrative component.
Would you like to amend that, or would you I think, let's take 2 minutes and you
Subject
write
to
that
Ms.
motion down.
Subject to Ms. Avers' approval. That way, it's, the wording, I think, will fit what is available out there.
Is it a course or is it a seminar? Or could it be a seminar that has all that?
Could include both.
You might have there may be a seminar that's 2 days, it's all commercial with no residential. I don't know. Either we can amend the motion on the floor, or we can withdraw that motion, and before we entertain another motion, I want to see it written down, very specific, so we can move on. We got 2 more items and a long day.
I will take a stab at this. I would amend that motion to.
I think from a point of order, you can't amend your own motion.
I'll take a stab at amending the motion to say that we're requiring a general report writing class with a commercial and narrative component to it.
Anyone restate that motion? Did it correctly? That means we all understand what's going on here.
I'll try to restate it. A general report writing class with a narrative component, commercial. Open, if it were left up to me.
Subject to your approval.
Maybe put a minimum of 15 hours.
Kind of, sometimes when you start actually looking for these courses, you're really limited in what's there. I'm not trying to, just be extremely lenient, but by the other token, I'm not trying to create a situation where there's not an option for the individual.
Let me interject. One way to maybe looking at this is we could ask Ms. Avers to between now and before we finish this, to get what's the educational content is approved by the state, and just kind of glance through it and see if anything meets the bill. And if it does, we just say that's the course, take that course. And then we can continue on with these other actions while she tries to do that.
Well, I think if we were going to do that, I would recommend the Institute course, but then you're back to where is it available? When's it available? That whole argument comes back up.
So we're going to give the respondent, 90 days to identify it and, 180 days to take it, or something that's reasonable.
Well, then I would support the Institute course, the 30-hour Institute course.
Guess that we go with the amendment as just read and leave the hours up to Ms. Avers to decide when the course is submitted.
And if that course is a 7-hour course that doesn't meet the content level that we're looking for, she can say that's not what we're looking for.
Absolutely.
And if something shows up from a provider that we did not know existed that's good, she can sign off on it and let it go.
I'm just a little afraid if we do that, we're really placing our problem in Ms. Avers' lap, and it's going to be a continuing festering sore as this person submits 7-hour after 7-hour after 7-hour course for approval.
Good point. Well, the Institute's general commercial writing course, that's different from the demonstration appraisal report writing course. Or are they the one and the same? Do we know that? The demonstration appraisal report writing course is very intensive, and it's only offered once every 2 or 3 years. It's not. I'm kind of thinking along the lines of Commissioner Walton. We need to probably just make it simple so that there's not a bunch of tick and tack back and forth. This is what you got to take. We're already giving them a break on a $2,000 fee. I don't want to drive the boat too much, but I'd like to see that amendment. I mean, the amendment or the motion probably withdrawn and a new one brought forth that just specifically says that course, so we can move on.
I'll withdraw that motion.
All right, we've got an open floor for the educational opportunity, and I trust Commissioner Walton has got this aced.
All right, I will step up to the plate once again. I'd like to make a motion that the respondent is required to complete the Appraisal Institute's general 30-hour general report writing class as corrective education to assist him in the areas where he has committed violations.
Have a motion, is there a second?
Second.
Second by Commissioner Johnson. I like it. We've got progress. Any discussion on this corrective education? If not, all in favor signify by saying aye.
Aye.
Any opposed?
Opposed?
Strike, Commissioner Standiford is opposed. Any other opposed? Okay, recommendation approved. Okay, item 3, respondent is assessed all investigatory and hearing costs incurred in this matter pursuant to Tennessee Code annotated 56-1-311, parentheses A, and Tennessee Comp Rules and Regs 0780-5-11-01, assessment of investigatory and hearing cost.
Make the motion that we accept the judgment as submitted by legal counsel.
Okay, we have a motion to recommend, to accept the proposed judgment under item 3 as submitted by general counsel. Is there a second?
Second.
Second by Commissioner Standiford. Any discussion? Not all in favor, signify by saying aye.
Aye.
All right, motion approved. Item 4. Under proposed judgment, this is the last item under that. The respondent is required to deliver evidence of his completion of the required corrective education to the Office of Executive Director and shall pay in full the $200. That would be $200 if we reference off item 1, which we've already changed. $200 civil penalty and all assessed investigatory and hearing costs detailed in the Commission's final order within 90 days of the filing date of such final order. Such respondents fail to comply with these requirements by the stated deadline, his certified general real estate certificate shall be immediately suspended and remain suspended indefinitely until he does fully comply with this order. In reference to this, I think it would need some modification based on the prior discussion of the corrective education course because of timing of those courses and so forth. That would give them a little, within 90 days, I think possibly within 90 days to identify the course and have signed up, and within have it fully taken within a year. I don't know if 180 days you could find it and take it. Is it offered that quick?
Well,
And if it's not, he could file for an extension up
What
to a
if,
year.
what if we modify what's here to say, we're modifying the $2,000 to $200 and evidence of his, instead of completion, substitute enrollment?
Perfect. Because that's what we're trying to get him, is enrolled within 90 days. I like it.
Right, and then possibly, I don't know what we do about evidence for the completion, because that's really the,
Well, where's the evidence of completion? No, I think
well,
ultimately
he'll need to submit evidence of completion.
evidence of evidence of what is that term you used? Enrollment. Evidence of enrollment within 90 days and completion within 180. See, the thing about those courses, it may be offered in August, and that's more than 180 days to get you to August. I would be willing to say enrollment within 90 days, because you're committing to that course. And those courses are generally a year out, and 365 days to offer evidence of completion, up to 360, as completed, up to 360 days, because that course may not be, it may be offered in Atlanta in November, in Sacramento in March. And, I personally would rather see him go to Atlanta, give him a little bit of latitude rather than having to fly to Sacramento. Because he's going to be able to identify where he can take it within 90 days and have his deposit sent and enrolled. That makes sense to me. So I think enrollment within 90 days and certificate of completion within 365 days. And Commissioner Walton, he's the motion machine today.
All right, I'm going to make the motion that the respondent is required to deliver evidence of his enrollment of the required corrective education to the office of the director and shall pay in full the $200 civil penalty and all assessed investigatory and hearing costs detailed in the commission's final order within 90 days after the filing date of such final order, and the completion of the corrective education within 365 days of the final order. Should the respondent fail to comply with these requirements by the stated deadline, his certified general real estate appraiser license certificate, not license, shall be immediately suspended and remain suspended indefinitely until he does fully comply with this order. That is my motion.
Is there a second?
Second.
Commissioner Walton has eloquently stated the motion, and it's been seconded by Commissioner Stanford. Any discussion on the motion? If not, all in favor signify by saying aye.
Aye.
Any opposed? Okay, motion is approved. So that covers the 4 items under judgment, and those are the penalty under item 1, the corrective education under item 2, investigatory hearing costs under item 3, and the response time frame and under item 4. So that leaves us, the last thing to consider is the policy decision for these findings of fact, conclusions of law, and judgment. And I don't have anything in front of me that would, can I ask the judge, what would be our policy? Can you give us an explanation of what that policy decision would be? Or how I know in the past we've had a matrix.
Most of the commissions and boards have a boilerplate that's used. A boilerplate that's used.
Yeah, there's a matrix, and I don't have,
It's ultimately for the protection of the
yeah,
public.
there was a matrix at
It's
one time that had all these,
protection of the public.
and I don't have that in front of me. And,
Anyone, do you have that, Mr. Joseph?
I didn't type it up as part of the proposed findings, of course, Your Honor. I could go get it from a former order upstairs, and if you give me a 5 to 10 minute break.
hold on, I think Ms.
Oh, it looks
Avers
like
may
Ms.
have it,
Ms.
something.
Avers may have it.
Stand at ease for about a minute. I'll read through this and see what we can. Okay. This is under policy reasons, under formal hearings. It says the Tennessee Real Estate Appraiser Commission is charged with the duty to regulate the practice of real estate appraising in the state of Tennessee, such that the citizens of this state receive all such services in accordance with state law and regulations. Because the respondent has violated the law and regulations governing the practice of real estate appraising, it is in the public interest of the citizens of the state of Tennessee and for the protection of their welfare that we have offered the 4 proposed judgments on the respondent, David W. Harris, Certified General Appraiser number 692. We have a motion to accept that policy.
Make the motion that we
Reason?
accept it as read by Chairman Johnstone.
We have a motion to accept. Is there a second?
Second.
Seconded by Commissioner Staniford. Any discussion? I have one question for the judge, if I can, if I may. I did not specifically list all of the proposed judgments.
But I think you said the aforementioned.
Yeah, is that
So
adequate?
that's adequate,
Okay,
yeah.
all right. Any further discussion? If not, all in favor signify by saying aye.
Aye.
Any opposed? Okay, policy decision is approved. I think
That concludes the contested case hearing.
that concludes
And the
the,
state will draw the final order for your signature.
okay.
Your Honor, I have one final matter. I want to let the chairman know, when I draft this proposed order and send it to you, Mr. Johnstone, proposed findings of fact on page number 1, I had stated that the respondent's certificate was active through December 31st, 2013. That was the case as of the time I drafted this and as of the time we filed the. I will update that to reflect the fact that he has since renewed with Mrs. Avis's office.
Thank you,
All right, thank you.
Counsel Joseph. Thank you, Mr. Judge
Thank you.
Williams. That concludes the formal hearing, and we do have some more items in our agenda. Would the body want to take a very quick break, maybe grab a snack? No full lunch or anything unless y'all want to do that. We want a full lunch?
Well, it's back there.
Oh, yeah, I mean, but do we want to take a full hour, or we just kind of want to get this thing up? I mean, what, 30 minutes? Okay. We're going to stand adjourned.
You out the door.
Always do that to you guys. Can't help it. Things happen like
Just one? I wanted two.
tell you, we're done. Well, technically two with one number.
Oh, that's better.
Yeah.
What are you doing?
Just adding
What
stuff.
are you doing?
Did Rosie leave?
Yes, she left.
Oh, that's a shame. She's gonna miss this.
Hey, we can send her a video copy. Take a video.
Recorder's on, just so you know. Didn't want to surprise you. I did turn the recorder on.
Oh, I thought you said Corker's on. I'm like, the senator's in here? What are you talking?
He came with the
Yes.
legal report.
Just didn't want you to
He
be
came for
surprised.
Keely.
Yep. Here's the extra one I have. Actually, it's on yours.
Oh, me. Ooh. In Memphis.
Thank you.
Mark. Walter Allen's still the big man down there.
Well, he's still down there. I think they're all fighting over the crumbs, man. I don't know that anybody's got Todd and them sold out.
Did
You
it?
got Integra, and then
Oh,
there's
yeah.
another group, Balgar or
Yes,
something.
yeah. Mm.
Todd, all these firms are trying
Mhm.
to join forces and
Mm.
do all this stuff. It's intentional.
That's a violation of use, Pat. It's misleading.
That's a violation of my conflict of interest statement. Did y'all sign those? No. All right.
Always have
Did
to
you
use the
know?
legal report.
All right.
I brought it with me.
We're coming back in session, and we have completed the formal hearing. It's actually 10 till 2, and we're under formal hearing resumes. whatever that is.
I mean, this is formal hearing.
I'm kidding. I'm kidding. I'm
I was
kidding.
like,
Formal hearing resumed. Just making it. I was just trying to be funny there.
and it was.
Keely.
It was
Anyway,
very funny.
so we're we're ready for the legal report.
I was just looking at him like, what? Okay. Sorry, I just shouldn't do things like that right before it's my turn. Item number 1 is 2013-012-121. This complaint was filed by a consumer and alleged the undervaluing of a residential property by using inappropriate comparable sales data. The complaint alleged that respondent used comparable sales that were close to or over 6 months old in appraising the property when more recent sales were available. In addition, the complaint alleged that the changes in market conditions were not taken into account, which constitutes negligence. Respondent sent a response to the complaint stating that it is recognized that the comparable sales are over 6 months old, as stated in the report. All sales are within the subject development. Respondent stated that general appraisal guidelines established by Fannie Mae, Freddie Mac, FHA, and VA will accept closed sales up to 12 months old. The use of subject development sales is a required guideline. The greatest emphasis of value is placed on subject development data. As of the date of inspection, only 4 closed sales have occurred in the subject development in the past 12 months, all of which were used in the appraisal. The sales chosen are the most recent and pertinent, which reflect the market for the subject development. The reviewer conclusions are listed there. Do you guys want me to read those, or would you rather read them? I don't know how you guys want to do that, but okay. I'll give you some time to read those then. Also, the respondent's response to those conclusions is directly
Everyone had an opportunity to.
I make a motion, we accept the recommendation of council.
Second.
Motion to accept, Commissioner Hall, seconded by Commissioner Barilla. Any discussion? If not, all in favor signify by saying aye.
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 Any opposed? Recommendation approved. Item 2, 2013017461.
Okay, hold on just 1 second, sorry. Just so we get it on the record too, I want to make sure that, I know you guys accepted the recommendation, but I just want to state what it is. For item number 1, The recommendation was that the matter be closed with a letter of warning. So,
That was my intent.
okay. I just wanted to make sure we read it into the record. Okay. Item number 2, 2013017461. This complaint was filed by a consumer and alleged that the appraisal report was performed with predetermined bias, which included questionable comparison selection, ignored market trends, disregarded circumstances pertaining to sales price for comparable, and manipulated value cost approach estimates to justify overall appraisal. In addition, the complaint alleged that respondent did not return the complainant's phone calls. The complaint alleged that the appraisal did not accurately determine the value of the subject home. Respondent sent a response to the complaint stating that the appraisal report in question was performed objectively with no bias and with no personal consideration. The results of the assignment are reasonable and fair. The reviewer's conclusions are listed there. In addition to respondent's response to those conclusions. So when you guys have a chance to read through those, I'll read the recommendation into the record and then you can decide.
I'm ready.
Hold on one second, sir. Okay.
This is in regard to item number 20130174661. I would like to close this with a letter of warning.
So we know, the recommendation from council was a 15-hour residential report writing course to be completed within 180 days of execution of the consent order. So,
Yes,
yep. Okay,
that's not my recommendation.
I know. I just want to make sure I read it into the record.
We have a recommendation on this to close with a letter of warning. Is there a second?
Second.
Second. Commissioner Brilla, any discussion? Not, all in favor signify by saying aye.
Aye.
Any opposed? Recommendation approved. Item 3, 2013016211.
Complaint was filed by a bank and alleged the original appraisal report included several red flags, excessive net and gross adjustments provided without support, across the board adjustments impacting up to 29%, valued subject 42% above the list price at 18% above the sales price with no comment, provided data much farther away than necessary, ignored data in closer proximity, and no comment on the difference between county records and measured GLA. Respondent sent a response to the complaint stating she remeasured the entire residence and found no significant differences with her measurements. Respondent noted some differences in the county measurements but cannot answer for them. Respondent stated that the subject area is very mountainous, heavily wooded, and secluded. However, the subject property is not. Subject was listed for $395,000. However, it was listed with only 10 acres. The sale was with 20 acres. Due to the acreage, the quality and size of the subject residence, and the large finished area on the lower level, adjustments were higher than normal. Due to the limited data in this rural area, this was unavoidable. And in this matter, the respondent was given the opportunity to respond to the reviewer's conclusions, but no response was received by this office. And I'm just going to go quickly through the reviewer conclusions just so that we can have those in the record too, because I think it's probably important. The subject information that includes the listing information did not adequately describe that the original list included 10 acres, while the sales contract included 20. The appraiser did not provide additional information on the type and extent of analyses applied to arrive at opinions or conclusions. The appraiser did not provide sufficient information on the physical, legal, and economic attributes of the property. The appraiser did not provide information on the taxes for the subject property. Appraiser did not analyze the relevant legal, physical, and economic factors to the extent necessary to support the appraiser's highest and best value. The appraiser did not adequately analyze the contract or the listing information. The appraiser did not reconcile the quality and quantity of data available and analyzed within the approaches used. And the appraisal did not contain sufficient information to enable the intended users of the appraisal to understand the report properly. And that's just a summary. You guys can read the rest of what's there.
In reading, this Commissioner Hall, and reading over the reviewer's conclusion, the green belt status on over 15 acres of farmland, in my opinion, wouldn't have had any bearing whatsoever on the value of it. Highest and best use, I think if it's a residential property and you got residential all around you, checking the box is what they asked for, that's what we should do. I do think possibly more explanation probably should have been given between the 10 acres and the 20 acres, which was actually sold. I don't know whether or not that's a working farm or whether or not it's just a large 20-acre tract of land. Or depending on what the sales were, not having access to the sales or any other information, it's difficult as a commissioner to make a decision on this one. There's not enough information in the review. There's not enough information in the appraisal, which we do. The appraisal does not contain sufficient information to enable the end user to understand the subject properly. The review that was done does not provide the commission with enough information, in my opinion, to properly review it either. I'm not saying that this property doesn't have any specific or does not have use path violation. I'm sure it does, but I'm not too sure that a 15-hour residential market and highest and best use would be applicable in this situation. And there are just some comments. I'll let somebody else make a motion on this one.
In my experience, doing a property 20 acres and that kind of thing, having adjustments that are pretty broad is not unusual. That's kind of what got this thing on the radar. I would make the motion to close this with a letter of warning as well.
I'll second it.
Motion from Commissioner Walton to close with a letter of warning, seconded by Commissioner Hall. Any further discussion? Not all in favor signify by saying aye.
Aye.
Any opposed? Okay. Item 4, case 2013-016.
No, he's good. I was just going to read the number, but you can read it. It's all good. Sorry, I didn't mean to interrupt you.
Item 4, case 2013-016871.
Complaint was filed by the property owner of a 19.5 acre tract of land. The complaint alleged that respondent made several misstatements of facts and negligently performed the appraisal, resulting in an undervaluing of the subject property. Complainant alleged that respondent appraised the subject property for $975,000 in June of 2013 and for $2,050,000 in April of 2012. The complaint alleged that both appraisals were as-is market value assignment and had the same highest and best use. Marketing exposure time was significantly different on the two reports, 6 to 12 months versus 1 to 2 years. Respondent filed a lengthy response to both the complaint and the reviewer's conclusions, so the responses will be summarized in the response to reviewer's conclusions section. In the reviewer's conclusions, the reviewer found the location of the subject property was incorrectly identified. According to the information gathered for the review, the subject property is located in a specific city and was identified to be outside the city limits of this city. The subject property's zoning was not correctly identified. The report indicates the subject property does not fall under any zoning restriction, but based on the reviewer's research, the property is zoned B1, General Business District. The appraisal contained inconsistency in some of the sales information provided and lack of analysis of pertinent information, including improvements, site size, and conditions of sale regarding some of the sales used in the sales comparison approach to value. And there are some of the examples listed there. And the respondent's response to the reviewer's conclusions is listed there. If you want to read over it, it's kind of lengthy.
Ready? When I look at this, I mean, it had recently been annexed into the city, and a lot of and the respondents' responses I thought were pretty good. I mean, he had the deed; he or she had the deeds to back up those the sizes, which we know CRS is not always accurate, and I don't know. I just thought I thought the response was acceptable to me. I don't know. It just seems like an excessive amount for something where it was just recently annexed into the city, and it may or may and it didn't appear to have had. It said it was a mixed use type property in or out of the city limits. So I'm not sure that it would have had a bearing on the comparable sales used based off what I'm reading. And I think they recognize. Go ahead, Commissioner Hall.
Okay, the question I had, did anybody address with the appraiser why the two different values within a year's time? Did anybody address that issue? I don't I don't,
Seems
I
like we
was-
reviewed one appraisal and probably should have reviewed two.
well, that's my point, I reckon, Commissioner Waltons, the fact that as far, if you take this thing, what we presented with right here, I say just close the matter. Of course, I am concerned how come we got a year's difference in here, a difference say between rounded $1 million and $2 million between April 12 and June 13th, with the one on June 13th being $1 million less than it was in April 12. I have no clue why, how come, and what for on that one, but based on what we have here, I'm gonna say close it.
I think both reports were reviewed.
Well, we don't have the information on that, though. We don't have any information on it. We got some information on here, and I don't know which report this narrative is addressing, whether it's addressing one of them, both of them, or I just don't know.
Kind of seems like one of them's got to be wrong. Yeah.
You know, it could be factors in there. You know, maybe when it was in the rural area, he could do whatever he wanted to do with it. Maybe that made it more valuable than it did once they put it inside the city. I don't know. But I don't feel like I got enough information here to tell this guy that we're gonna penalize him $1,000.
Yeah, and you don't know what the data set was in the 2012 versus the 2013. But if they were reviewed, and both reports were reviewed, and there was a problem there, then the reviewer should have picked that up real quick.
You know, we should have been able to then make some determination as to what was going on. But without any more information, I'm gonna say we recommend this, just close with a letter of caution.
Heard the motion. Is there a second?
I'll second.
A motion and a second to close with a letter of caution. Any discussion? I'll just add to that, when we get one like this, where there's a difference in value that's it's significant within a short time frame, then I would ask legal to do some extra investigation into that as to why, or have the reviewer explain why that's the case. All in favor signify by saying aye.
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 Any opposed? Recommendation approved. Item 5. Item 5. Case 5. 2013-011-711.
Complaint was filed by a consumer and alleged that respondent undervalued a residential property by using inappropriate comparable sales data, causing the complainant permanent harm. Respondent sent a response to the complaint addressing the issues brought up by complainant. Respondent stated that in his appraisal, he stated that exposure time for the subject is typically under 6 months, except for the most unusual properties. The subject is a unique improvement. More importantly, there are limited sales and listings of attached improvements similar to the subject. There is not supportable data that would allow a comparison of attached and detached units. Respondent stated the value of a 1-year difference in age cannot be extracted from the subject market, and based on use PAP, an adjustment cannot be made if it lacks support from the market. The value differences of a first floor bedroom and a second floor bedroom cannot be extracted from the subject market. The $21,000 adjustment to this listing is required by Fannie Mae and is based on the 1004 MC and market trends, not value. This is not a deduction from the subject property, but of the listing. Respondent noted that complainant stated that the sketch of her home that respondent presented in the appraisal omits both her patio and the porch off the mudroom. The concrete slab off the mudroom is a small pad with a concrete walkway to the deck. The deck is in respondent's sketch. However, looking at the hand-drawn sketch, respondent did notice that he failed to include the patio at the side of the subject property. The reviewer conclusions, I'll just try to summarize those. The appraisal failed to summarize the information analyzed, the appraisal methods and techniques employed, and the reasoning that supports the analyses, opinions, and conclusions. With regard to the sales comparison approach, several erroneous reporting items were noted with regard to sale 1. The report indicates the property is 7 years old when it was actually built in 1954 and is 59 years old. The report indicates no seller concessions, but MLS indicates that $15,000 of seller concessions were paid, and the report indicates that the contract date is 11/12, but MLS indicates that it is 10/12. In addition, the sale is approximately 1,000 square feet larger than the subject, and is listed in MLS as having been on the market for 0 days. Sales number 2 and number 4 have the wrong picture in the photo addendum. The MLS for sale number 4 states the property is priced $50,000 below appraisal and eventually sells for $69,500 below the list price after being on the market for 161 days. This property sold around $100,000 less than all the other sales used in the report, yet it is treated as an arm's length transaction, and there's no explanation in the report for these discrepancies. The appraisal report indicates that normal marketing time is 3 to 6 months and that exposure time is under 6 months. Sale number 3 was on the market for 251 days, and comparable number 6 has been on the market for 258 days. There is no explanation as to why these properties exceeded the normal marketing and exposure times of less than 6 months. All sales used in the sales comparison analysis sold more than 6 months from the effective date of the appraisal. 4 closed sales and 2 active listings are utilized in the sale comparison approach. These 6 indicators provide a high-low distribution of value from $459,500 to $676,700, a range of $217,200. The report concludes to a value opinion of $550,000. The contract price of the property is $605,000, a difference of $55,000. Standards require an appraiser to reconcile the data in order to provide the rationale for the final value conclusion. The appraisal report states the highest and best use is the current use of the property, but there is no summary of the support or rationale for this opinion. Respondent was given an opportunity to respond to the reviewer's conclusions in the matter. However, no response was received from respondent. Due to the nature of the violations noted above, council recommends the authorization of a civil penalty in the amount of $500 to be satisfied within 30 days of execution of the order, and a 15-hour advanced residential applications and case studies course to be completed within 180 days of execution of the order. Such terms to be settled by consent order or formal hearing.
The legal on this case. Any action by the board?
Accept council's recommendation.
Second.
A motion to accept council's recommendation by Commissioner Barilla, seconded by Commissioner Hall. Any discussion? If not, all in favor signify by saying aye.
Aye.
Any opposed? Recommendation approved. Item 6, 2013018-791.
Complaint was filed by a consumer and alleged that respondent overvalued a residential property by using inappropriate comparable sales data. The complaint alleged that respondent lacked objectivity and accuracy in the appraisal report, resulting in what complainant believed to be a much higher value for the property than what can be supported. Additionally, the complaint alleged that respondent violated the appraiser independence guidelines by conversing with the selling realtor and obtaining comparable properties from the selling realtor's office, as well as conversing with the lender prior to the report release. Respondent sent a response stating the allegation about conversing with the seller's agent was false. Respondent stated she had to call the listing agent's office to get permission and the information needed to gain access to the property. There was no conversation about value, and she never spoke to anyone at the lender's office. In choosing comparable sales for the property, respondent stated she opened every single photo to see the interior photos of each sale that was available, as the subject is the best renovation that she's seen in the area. Respondent stated she only utilized totally renovated comparable properties with basements for use in her report, and for these reasons, they were the best comparable sales available. Respondent stated the subject is not located on a busy street considered by most market participants. The electrical lines in the front run down every street in the area and are therefore considered typical. The unfinished area in the basement that complainant spoke of is the mechanical laundry room pictured in the report. These small areas are typically, not taken out of the finished square footage by appraisers, whether it is above grade or below grade, as this room is vital to the function of the entire dwelling and necessary. Respondent claims that all of complainant's allegations can be summed up to meritless intimidation to try to influence her into lowering her final value opinion of market value and impact her independence as an appraiser. The reviewer conclusions are as follows. The subject's listing history is not correctly stated in the appraisal, and I've sort of summarized that. They Market conditions section does not contain any data analysis or support for the opinion of one-unit housing trends or the one-unit housing. The appraisal does not correctly show the specific zoning classification or the correct zoning description. The appraisal offered no discussion of the renovations and updating that would lead the intended user to understand why the value increased $140,000 in less than 6 months. An analysis of the neighborhood boundaries indicated an increase in the median sales price for the market area, and the appraisal does not show an adjustment for the increasing values. The opinion of site value is not supported. An appraisal or work file data does not show the breakdown of the extraction method which was stated to have been used. The appraisal does not provide a discussion of the sales comparison approach in the reconciliation, summary of the sales comparison approach, or any other areas of the report. And the respondent did not respond to the reviewer's conclusions.
Ask a question, Keely. Okay, the respondent did respond to the initial request from Ms. Avers or from yourself,
The initial complaint that
to the
was
initial
filed.
complaint.
Mhm.
And then, did they have the reviewer's comments at that time?
No. Then once we send it out to the reviewer and I get the review report back, I send out sort of it's like a summary of the reviewer's conclusions, and they have 10 days on back to that.
Thank you.
I make the motion that we accept legal counsel's recommendation.
Second.
We have a motion to accept legal counsel's recommendation. Can counsel read that recommendation into the record?
Council recommends the authorization of a civil penalty in the amount of $500 to be satisfied within 30 days of execution of the order, and a 15-hour residential report writing and case studies, and a 15-hour advanced residential applications and case studies course to be completed within 180 days of execution of the order. Terms are to be settled by consent order or formal hearing.
Any discussion?
Yes. We're requiring, the recommendation is we require them to take 2 courses, is that correct?
That's correct.
Both of them 15-hour courses?
Yes. And a
Well-
$500 civil penalty.
Will they get credit for CE?
Seems excessive. Maybe one
Surplus
class.
hours of CE credit. I mean, you could,
Um, Dr. Barella make the motion, or did Commissioner Walton?
I made the
Commissioner-
motion.
Commissioner
second.
Walton, seconded by Commissioner Umbrella.
To me, it just, and looking it over and everything, it just seems a little bit excessive. One of the things in here that I picked up on says that the subject site backs up and sides to a TVA power line easement. And nothing is said about that. Well, I just got through doing an appraisal assignment, Piedmont Gas, that runs all the way from Murfreesboro Road over to Tyne, I think it's Tyne. No, Chickering Road. And it's following the line of existing TVA easement. And in my contact with all of these individuals, with the price range of the homes ranging from $120,000 up to over $3 million, not a one of them ever made any comment about that TVA easement there taken away from the value of that property. So consequently, I don't really believe that's an oversight or whatever the case may be. I don't know where this property is located, but I would be concerned if that was one of the reasons for, this person having to do all of this. To me, one of the other courses would be fine, but I have a little bit of problem going with both of them. And I don't know whether Commissioner Walton or Commissioner Barella would like to, state that motion or not.
I withdraw the motion.
I'll withdraw the second.
Walton, would you make a new recommendation, please, sir?
Why don't you?
And I just feel like either one, both of them are just a little bit too much. Anybody else have any feelings about this other than me?
Well, I agree 100% with you in reference to the power line easement. It may or may not have any bearing, and in my experience, that if it is, it's nominal at the most. And so not referencing that, not making an adjustment for that, I think it's, till you know the whole circumstances, you can't, that's a hard one to try to pinpoint. 'Cause I see them building houses backing up to them all the time. So, yeah, I think that's a little bit of an issue, and so sometimes I think when these things start jumping out, and you see this and you see that, all of a sudden you start piling on, although it may not be something that needs to be piled on. So we only need one course if we're gonna do that, and I'm not sure that if the rationale for that is this one easement adjustment, then I have a problem with that, but I think there's some other things there that, might be.
I would like to make a motion that we are a 15-hour and case studies. I don't know whether I need to.
You've heard the motion. Is there a second?
So is your recommendation for the 15-hour advanced residential applications only?
Yes.
Okay.
Is that a recommendation or a motion?
Motion.
I'll second.
Motion from Commissioner Hall, seconded from Commissioner Walton to take a course only.
Yep.
Any discussion? If not, all in favor signify by saying aye.
Aye.
Any opposed? Motion approved. Item 7, 2013-011-481.
This complaint was filed by a consumer and alleged, that respondent undervalued a residential property by using inappropriate comparable sales data. Respondent sent a response to the complaint stating that, as stated in his report, he used the most similar comparable properties within a 2-mile radius of the subject over the past 12 months, with no reason for an expanded search for additional properties outside of the subject's immediate market area. Respondent stated he believed the appraisal report delivered to his client is USPAP compliant and offers a credible opinion of market value based on the scope of work defined in the appraisal report. The reviewer conclusions are as follows. An opinion of site value is provided in the cost approach. The report refers to recent land sales found in the area as support for the indicated value of $24,000. However, no land sales are included in the appraisal report, and no land sales are found in the appraiser's work file submitted to the reviewer. Since an opinion of site value is by definition an appraisal, all applicable standards, rules, and standard 1 and 2 are required of the appraiser. The opinion of site value is an opinion of market value, which requires an opinion of highest and best use. The content of a summary appraisal report must contain a summarization of support and rationale for the appraiser's opinion of highest and best use. This is included for the subject as improved, but not provided in the report for the subject as vacant. Several assumptions are identified throughout the report as extraordinary assumptions. When using an extraordinary assumption, the appraiser must state that its use might have affected the assignment results. The statement is not found anywhere in the appraisal report. Respondent sent a response to the reviewer's conclusions stating that he was reattaching the land sales that were in the original appraisal work file. Respondent stated he was fairly certain that these were in his work file copy that he submitted to the appraisal commission. However, his work files are large, and he apologized if it was not copied in the report. With regard to the highest and best use issue, respondent stated he had a couple of statements in the report regarding highest and best use. One is located in the URAR itself, and the other is located in the attached supplemental addendum of the original report in the highest and best use section. The Aston use vacant and as approved is stated in the original report as the current single-family residential use because of the SFR zoning, legally conforming utilization, and the site lends itself to single-family residential use both because of its size and topography and compatibility with surrounding sites. Regarding the extraordinary assumption comments, respondent stated there's a full section located within the original report. Respondent did attach the language that he referred to there in his response, along with the land sales that were apparently missing from the first file. The reviewer found the quality of respondent's work was overall good and acceptable, with a few minor deficiencies in USPAP compliance. It was the reviewer's opinion the appraiser made obvious efforts to provide a meaningful and professional report, which only needs a few minor adjustments to be compliant. As such, council recommends this matter be closed with a letter of warning regarding the minor violations noted above.
I'd like to make a motion that this be dismissed.
Second.
We have a motion from Commissioner Hall, seconded by Commissioner Walton for dismissal. Any discussion? If not, all in favor signify by saying aye.
Aye.
Any opposed? Item 8, 2013-015-451.
This complaint was filed by an appraisal management company and alleged that an appraisal desk review of the respondent's appraisal report stated there were significant problems which affected the reliability of the report. Respondent did respond to the complaint, but only to send in a copy of his work file and documentation requested by this office. He didn't directly respond to the specific allegations within the complaint. The reviewer conclusions are as follows. The appraiser failed to summarize information sufficient to identify the real estate involved in the appraisal. The subject property is located southwest of the subject city. The location map provided in the appraisal report shows the subject on the east side of the subject city within the city limits. The report indicates that the subject neighborhood is rural, which is correct, but the map indicates the location to be suburban, which is incorrect. None of the maps or neighborhood boundary descriptions are correct. The appraisal report does not have an opinion of exposure time. An opinion of site value is provided in the cost approach. The following statement is provided in support of the site value. The site value is obtained by comparable land sales within the area. The appraisal report dated February 10th, 2012 did not include any land sales or specific support for the indicated site value. Substantial adjustments are made to each of the comparable properties for differences in contributory site value. However, none of these adjustments are summarized or supported either in the sales comparison comments of the report or in the work file. Cell number 4 is also adjusted a minus $20,000 for location. There's no explanation for this adjustment or support for the amount. In addition, 2 of the 4 cells used in the sales comparison approach are located in another state 18 to 23 miles away, with no explanation as to why the appraiser used out-of-state sales. An insufficient reconciliation is found in the sales comparison approach to value. There is insufficient explanation to explain how the appraiser arrived at the final value opinion of $575,000 from the wide range of adjusted values indicated in the report. The only sales that support a value this high are out-of-state sales. The sales in this state and closest in proximity to the subject support a much lower value range. The appraiser made unsupported assumptions about market area trends. There is no summary of the support and rationale for the opinion of highest and best use. There is no statement in the certification that the appraiser has or has not performed any services on the subject property within the past 3-year period. And respondent did not provide a response to the reviewer's conclusions in this matter.
And what's council's recommendation?
Civil penalty in the amount of $500 to be satisfied within 30 days of execution of the order, and a 15-hour site valuation and cost approach course to be completed within 180 days of execution of the order, to be settled by consent order or formal hearing.
I move we accept the recommendations of council.
Second.
A motion to accept council's recommendation by Commissioner Hall, seconded by Commissioner Standiford. Any discussion? If not, all in favor signify by saying aye.
Aye.
Any opposed? Motion approved. Item 9, 2013-017-541.
Complaint was filed by a citizen who's also the attorney for the complainant and alleged that the opinion of value is not supported in respondent's appraisal. The complaint alleged that the predominant value that is listed in the appraisal report is extremely high for the area. The complaint also alleged that there is no analysis of the sales contract, and all of the sales far exceed the typical price paid for this type of property in the market. Complainant also alleged discrepancies with the cost approach and alleged that the opinion of value is not supported. Respondent sent a response to the complaint stating that she disagreed with the allegations and included a copy of the appraisal and a copy of the work file in her response. The reviewer's conclusions are as follows. The one-unit housing and present land use percentage is inconsistent with market data found through the MLS system and based on visual observation of the surrounding communities. There's no analysis or discussion of highest and best use. Additional information needs to be provided detailing the quantity and quality of materials used throughout the dwelling in order to provide an analysis for comparison between the subject and the comparable sales and support the quality rating used in the cost approach. With regard to the sales comparison approach, the appraisal failed to make proper adjustments within some of the sales, and some were not supported by tax records, and I've listed this specific sale and listing numbers there. And the site value of the cost approach was not supported by the MLS listed comparable sales that were researched. None of the 3 lot sales used in the appraisal were comparable to the subject's non-Lakeview lot. And the respondent's response is also listed there. I'll give you a chance to read that.
Looking at the reasoning and recommendations, we have a $500 written out civil penalty and a $1,000 numerical penalty.
Yes, I meant for that to be 1,000. I apologize.
Council's recommendation is for a $1,000 civil penalty. That's it.
Yes.
Okay. Excuse me? Okay. Let me make sure I understand this. It was filed by a citizen attorney, or a citizen that happens to be an attorney.
Right, he is the attorney for the complainant.
So the complainant had an attorney file it for him. I don't understand why they had to be noted as a citizen. I've got a question for council. What's the specific ethics rule that was violated here? I mean, maybe I misread something. I mean, under here,
don't-
reasoning,
I
it
don't
says
think
that
you did.
misdirecting the value to an unsupported conclusion. I mean, were they trying, I didn't, and then when I read, and when you get off of standards rules, that's one thing. You get into ethics, that's a different animal. And I just want to make sure I understand, what the recommendation is. Sure.
It doesn't state in the review exactly which part of the ethics rule it is. So it's based on the numerous. It says the appraisal has numerous inconsistencies in the reporting, omissions of specific information that affected the value of the comparable sales, misdirecting the value to an unsupported conclusion in both the sales comparison and cost approaches based on the numerous omissions and commissions, violations of the ethics rule and competency rules have been violated. But it doesn't state a specific section.
Were you saying it was a misdirection based on an intentional misdirection, or it was just an inadvertent misdirection because of some errors?
I'm not saying either one because it's not stated in there.
'Cause in my mind, there's a big difference between a mistake of the heart and a mistake of an accident. If you intentionally are doing something, that's a big problem. If it just happened because you didn't really know what you were doing, to me, that's a little bit easier to stomach. Just trying to figure out what's going on.
Standard, did you knowingly, would you know at that time?
But then it's just a fine is all we're doing, no educational opportunity. So I don't understand.
You can add some educational.
No, I'm not saying add, I'm just saying, and Director Avers agreed with it, so I figured she had some insight into why this was the best way to do it. I'm kind of, I'm confused. I don't know what to do here.
Instead of getting bogged down for the sake of argument, I'm going to make a motion that we accept council's recommendation of a $1,000 civil penalty.
Have a motion, is there a second?
Second.
Second by Dr. Barilla. The only thing that bothers me about it is that ethics deal. Did the reviewers say anything about ethics? They just say standard rules 1-1A, 1-4. Yes, sir. Commissioner.
Does the reviewer, my question was the same question you just asked, does the reviewer reference
Only in the portion that I read to you.
They reference standard rule violations, and I can live with that, but I don't see any specific reference to ethics or competency in the reviewer's comments. The only place I see it is in the reasoning and recommendation, and that may have come from the reviewer or not. I don't know who that came from.
One of the problems, pardon me. No, one of the
Did you have a question as to where something came from?
Yeah, I mean, okay, the only time I see ethics is under reasoning and recommendations.
Right,
Now, who writes that, you or the reviewer?
well, I write the whole thing, but it all comes from the reviewer.
So the reviewer somewhere said ethics, but he doesn't mention it in the
I mean,
report anywhere. He
he-
just mentions standard.
He
rules.
says, it's just the portion that I just read to you, but he does not reference a specific part of the ethics rule.
One of the problems I'm noticing is the reviewer says, sale number 1, the expired MLS sheet shows 2,170 square feet, but states a full basement. This is not supported by the tax records obtained by CRS tax. It shows a crawl space. There's no support for the respondent square footage. Well, what square footage did the respondent use? Said Ford's located in a lake furnished community, has a panoramic superior lake view of the main channel. It has several large deck areas and a crow's nest deck on the top of the house. The appraisal did not adjust for the superior lake views or the multiple decks. Well, how much do they think it should have been adjusted for then? Are they making an appraisal? And if they're making an appraisal and they're criticizing the adjustments made by the appraiser, then where's their appraisal to back up their opinion of value? I just have trouble when the reviewers make these comments, and then we don't, and another one here, it says that the appraisal, MLS data on square footage is not the same as shown on the appraisal when compared to the tax records. MLS shows 1,085, tax records show 1,167. Well, that's nice. What did the appraiser use? I mean, we're given information here, but we don't have it. How does it tie in? Where's the discrepancy and who did what, when, and where? I mean, we just got a discrepancy between tax and MLS. Okay, I'll buy that. I don't know. I just feel that some of this information right here that we're being asked to make judgment on, we've not been provided with enough data to make a judgment call. And like Mark pointed out, Chairman pointed out also, we got a violation of ethics and competency. Well, I don't know if we're going to get into the competency rule, then they ought to have an appraisal to back up to show why this appraiser is incompetent, which we do not have.
Right, I would just say that if you don't think there's enough there to show probable cause to support the recommendation, then just don't go with that recommendation. I mean, that's the only thing I can say. We're not putting on all the proof at this stage. So I guess everything can't go into it. So, but I've reported everything that the reviewer reported. So I would just say if you can't find probable cause to support the recommendation, then just vote it down.
The motion on the floor is to accept council's. Any further discussion? Not all in favor signify by saying aye.
Aye.
No.
No?
No.
The new motion,
That motion does not pass.
Okay.
The floor is still open for any action or no action.
I just we send her a letter of caution.
I have a motion from Commissioner Hall to send a letter of caution. Is there a second?
Is there additional information that we should be made aware of?
Second? We can discuss it.
Second.
Motion from Commissioner Hall, seconded by Commissioner Standiford. think the question is there additional information that we may not be aware of?
Not for me. I don't know. I mean, I really did put everything from the review into the report, so I don't have anything to add.
Other information anybody would like to comment on at this time? Welcomed.
I get the feeling Nicole has something she wants to say.
I really think that some of the allegations are pretty serious on this one.
But there's nothing to back up the allegations, so that's a problem.
All I can say about it, I mean, we can't put on proof on every case, so.
Any other discussion? Recommendation is to send a letter of caution. All in favor signify by saying aye.
Aye.
Any opposed?
No.
Got one opposed. That's Walton. Recommendation approved. I think there may be one more
Yes,
that you
there
handed out.
is an item number 10. It's a supplemental item. It actually is 2 complaints. 2013019811 and 2013020051. Did everybody get a copy of that? Okay. These 2 complaints were filed against the same respondent appraisal management company. The first complaint was filed by the administrative staff of the Tennessee Real Estate Appraiser Commission for failure to maintain a valid surety bond after receiving notice of a cancellation of respondent's surety bond. The second complaint was filed by an appraiser and alleged that respondent did not pay appraisal fees for services rendered within the requisite 60 days, and the emails to respondent have not been responded to. Respondent has not submitted a response to the first complaint regarding the surety bond that was canceled effective 9/26/2013. Certified mail that was sent from this office was returned marked not deliverable. When staff called respondent's number, the operator answered with a different company name and informed staff that respondent was leasing this office and it is no longer at this location. Staff also called respondent owner and left a message. Staff did receive email correspondence from an individual associated with respondent who stated he was passing the information from staff along to the president of the company. However, no response was received and no valid surety bond was ever received after this communication. With regard to the second complaint concerning respondent's failure to make payment within 60 days, respondent controlling person sent a response stating that he had resigned as of October 17th, 2013, and asked if he could be removed as the contact and compliance officer for the respondent AMC. Respondent controlling person stated that his resignation was due to the extreme lack of payment from the AMC and its president. The controlling person chose not to be associated with respondent AMC any longer. The president of respondent AMC sent written correspondence stating that the complainant's accusation in non-payment for a property completed through respondent company is unknown. Any reports completed have been paid in full. Respondent stated that if this company was not paid for any service completed, the appraisal company did not follow respondent's engagement letter that is provided on all appraisal requests. Respondent president stated that at no time was respondent not fulfilling its obligations to any appraiser. Since respondent no longer has a valid surety bond with the state as required by the laws and rules of the Tennessee Real Estate Appraiser Commission, and since respondent did not respond to the state's attempts to contact them regarding the bond, council recommends the authorization of a voluntary revocation of respondent certification to be settled by consent order or formal hearing.
What happened to the appraiser? Did he just get cut out of the picture?
The appraiser that filed the complaint,
As far as his fees are concerned?
well, I guess we can't really make them pay him. Only thing we can do is just make sure that they maintain the surety bond. We can't.
We have a motion to accept council's recommendation to authorize a voluntary revocation of the respondent's certification by Commissioner Standiford. Do we have a second?
Second.
A second, Commissioner Barilla.
Discussion.
Now discussion, Commissioner Hall.
Is there any way, Keeling, on this we can put on there if they
Whatever you want in the language of the consent order, that would be for voluntary revocation.
track. Just for points of discussion, it would be really, really hard to track.
I reckon the problem you got is if it's ABC,
Very difficult. It's not like licensing individuals where we have individuals tied to a social security number.
Even if you flagged it, it would probably be kind of difficult if they applied under a different. I mean, you can do whatever you want, but
well,
it
I
just
know
might
that,
be.
but once again, I'm not trying to create problems, you know.
Any other discussion? Not all in favor of, signify by saying aye.
Aye.
Any opposed? Okay, recommendation approved. All right, that concludes legal. I have one item as a reminder, I want to remind everybody, Nicole had sent out the annual conflict of interest statements, and if you have not signed those for her, probably need to get that done. Is everyone up to speed on that, Nicole?
I don't know, actually.
This is just a general reminder that you need to get that done for her. And is that any other business? Since there's no further business, this meeting of the Tennessee Real Estate Appraisal Commission stands adjourned.
Good deal, good job, Mark, good job. Get that thing going on.
I had an interesting call from about these evals. Do we have where appraisers are doing commercial valuations?